for judgment, item 1 of daily leave.
For reasons mentioned in the judgment, this appeal is allowed and the impugned judgment dated and impugned judgment passed in sessions case number 2 of 2018 is hereby set aside. The appellant shall be released from jail and forthwith unless he is required to be detained in connection with some other.
Item 2.
For reasons mentioned in the judgment, the impugned judgment is hereby set aside. The appeal is allowed. The appellant is to be released immediately unless he is required to be detained in connection with any other.
Deeply organized.
3.
Appeal allowed.
I'm deeply obliged.
Who's your senior?
A.R. Sikdar. Well, in this case, my lord, the person was initially suspended on a false case, my lord. Thereafter, he challenged the case restatement, and restatement was allowed. Now, my lord, he is acquitted from the charge and he has been transferred to another school. That order has not been complied, my lord. My lord, he is now in hanging in balance, my lord. He is not allowed to join in the new assignment, my lord.
Which assignment?
My lord. Lordship may kindly have a look at, my lord, the speaking order at page 54. At page 54.
Yes.
My lord, finding, my lord. I am reading finding. To comply the Honorable High Court's order at so and so. But at the time, no vacant post was available in government junior basic school, Kasar, under the Kasar district, reported by the BO. As there was no alternate post available, the petitioner Mujibur Rahman Borgohain was reinstated in his original post of headmaster of Rangpur Government Basic School by so-and-so, in compliance of the Honorable High Court's order at so-and-so. Mujibur Rahman Borgohain has already been accused in so-and-so cases. There is no ongoing case against him under the POCSO, and the same is students of objection. The Mujibur Rahman, headmaster of the school, who is a POCSO accused teachers, repeatedly harassed so-and-so, and ultimately, my lord, he was posted at practicing government senior basic school, Udarban, Kasar district. Vice Sirajul Haq Mujibur, headmaster, retired with immediate. That case, my lord, he is acquitted from the that case, my lord, that is in order. I have annexed as annexer 1 at page 22. Now, my lord, there has been a subsequent order. My lord, annexer at annexer 10 at page 56. I was allowed to join in practicing government senior basic school Udarban. By Shri Sirazul Haq Muzumdar headmaster retired. But this order has not been complied. There has been subsequent communication annexer 11 page 57. And I am pursuing the authority, my lord. My last representation is at page 63. Since no case against me and I am not allowed to join in the new school, so appropriate step may be taken by the authority. That was not taken, my lord. So, my lord, my last representation at page 63. That may also be with a direction to dispose of.
Yes,
My
sir. Beku, what instructions do you have?
My lord, after that letter, my lord, page 61, my lord. This was a letter from the director to the additional deputy commissioner education Kachar.
Oh,
Thereafter, my lord, the district development officer in district development commissioner, my lord, by letter dated 18/5/23 has asked for a printer to question again.
yes, I have.
In this context, you are requested to take immediate necessary action for joining of the petitioner in his new place of posting. That was the letter from our. After that, what happened, my lord? That department will be. A letter was also given to the deputy inspector of schools, my lord, wherein, my lord, it was requested to submit the factual report of the matter, my lord. So, my lord, the department will be the actual authority.
Regarding this, I have to take ফাইলটো বিচাৰিব বেলেগ কথা ক'ব নালাগে।
Yes. But Mr. Shifter, let me also put a petition. Mr. J. Bekul and its government submits that after the letter dated 27th of February 2023, which was written by the Director of Elementary Education, Assam, and addressed to the Additional Deputy Commissioner, Kachar. Deputy Commissioner within the
Yes,
division,
the matter will
Gotcha.
be in next week.
comma, the
Nine.
Additional Deputy Commissioner
Nine.
had written to the Deputy Inspector of Schools. No, the District Development Commissioner, Pacha, had written to the Deputy Inspector of Schools to submit the factual report of the matter and take necessary action for compliance of the order. Stop. Para Mr. J. Beku, Leonard, Standing Council, Elementary Education, prays for how much time? 1 week. 1 week time to enable him to receive instruction. Praise a lot. Least after 1 week.
Seven.
May I please, Lordship? My lord, in this regard, in this case, my lord, they have filed the affidavit in opposition on Wednesday. I have filed the affidavit, my lord, it is up today. So matter may come on, my lord, Monday, along with item number 8, my lord.
Both 7 and 8 on Monday.
Both 7 and 8 on Monday, my lord.
Okay, on request made by the parties, list the matter on content. 7 and 8.
Register to be directed to take the affidavits, my lord.
Both same order. In item 7, just say
See, in item 8, both the affidavits are to be checked.
item 8.
Yes.
In item 8. Say that Mr.
Yes, file a reply to the affidavit.
B. Purkayastal, the counsel for the petition submits that he has filed the reply affidavit this morning.
Yes.
So we'll just need to verify and place the statement.
Nine.
For the timing, my lord. Is Piansu, this is engaged here. So after. At least.
Item 10 and 58.
My lord, this matter will be argued by AK Professor. He is coming, my lord. It may be taken up after some time, my lord.
Item 10 and
And
58.
58 supplementary. Supplementary is for implement.
Then we can implement,
Yes, my lord.
you'll have to file a amended cost title. Then after that, we'll take up along with this on a different date.
My lord,
We'll
will
permit
be
him.
taken up after some time, my lord. Yeah.
What's the point of wasting time?
11.
May it please your lordship. Lordship, here in this case, lordship petitioner is selected for grade 4 post lordship. He is a disabled candidate lordship. According disabled locomotive disability lordship. Page 43 lordship qualified for result sheet lordship.
Page
43 annexure 11.
yes.
The department of so shall be declared latest the 9th so and so website so and so lordship qualified for appointment lordship. Then lordship another notice was issued for medical examination of PWD candidate page 45 lordship annexure 12. Petitioner already appeared on that medical test lordship. He is a locomotor disability lordship. And his name lordship appeared at page 47. Altaf Hussain Badwiya. Serial number 19 lordship.
Yes.
Then lordship an order was passed page 48. On 35/2023 lordship. In person of the government personal department of reports appointment order of the following candidates recommended for the state level recruitment commission for class 3 and class 4 posts in different categories of posts are hereby kept on hold till final outcome of the receipt regarding their credential status of disability lordship. My name is serial number 12 lordship in the said page 48 lordship.
Page,
Page 48.
serial number,
Serial number is 12 lordship. Altaf Hussain Badwiya, Kolarpar ME School, Hailakandi district lordship. Name of the post grade 4 school chowkidar lordship. Thereafter lordship for holding of that again the government has issued a notice on paper publication lordship page 50 lordship regarding medical examination lordship. But the petitioner also filed his application on the basis of that, since his name was kept hold, but he was not called for remedial examination lordship. I collected the list of that lordship by virtue of that lordship 2/8/2023. That list, in that said list, some other candidates were called for, but petitioner, my only limited prayer is that lordship let me appear before the remedial for remedial.
Let us see for what reasons they have not called you.
Yes. Lord. Next stage notice may go a lot. And we'll.
No, no, why should I issue notice? You
Otherwise,
just
Your Lordship,
take
we'll get our instructions, Your Lordship.
a 1 week time.
1 week time, Your Lordship. We'll get our instructions.
But Mr. K. Majumdar, learned counsel for the business. Mr. A. Fukan, learned standing counsel,
Elementary education.
elementary education, shall receive instructions.
My appeal is also pending. In the meantime, Lordship, my post may not be filled up Lord, because some of them are selected, Lordship. A fixed date maybe
You want it after a week,
17 maybe, Lordship.
1 week time, this
1 week.
21st.
21st. Deeply obliged.
Much obliged.
Well,
May I please,
Yeah.
Lord, this petition regarding the transfer the petitioner as the full-fledged headmaster, any vacant post of the headmaster, my lord. Initially, he was appointed as the headmaster of CP Girls High School, Kamrup, my lord. Thereafter, he is engaged as a FLO in NRC duty, my lord. After completing the NRC duty, when he is going to resume his duties at original school, my lord, the local public and the staff of the school, my lord, is prevented to join there. Thereafter, the
Notice is going, this is outtake instructions.
But Mr.
emissions.
M.S. Ansari, learned counsel for petition issue notice.
I have for all the respondents, 1 to 3.
Mr. S.M.P. Chisti, learned standing counsel. Secondary education applies on behalf of all the extra copies. It's going to allow to file affidavit. This-
No, yes, yes. After 4 weeks, yes.
4 weeks.
14.
May it please your lordship. My lord, this matter pertains to the appointment of an assistant professor. I'll go to. It's an impugn order, your lordship. I was selected as a petitioner was selected actually for the in the said post.
Where's the advertisement?
On the basis of merit, actually. Notification is there, your lordship. Office notification is there. Page number 40, your lordship. Sorry, page number 39 and 40 included. Page number 39.
Which?
Page number 39, your lordship.
Yes.
So, on 29/1/2022, this letter was issued. So pursuant to that, your lordship, interview was conducted, and accordingly, in a college called BHP College in Barpeta, I was selected, and the selection committee approved my selection, and on the basis of merit only, proposal was given to the Director of Higher Education. Now, one of the candidates. May I be allowed to submit in brief, your lordship? Now, one of the candidates filed a writ petition last year. So, but the writ petition was dismissed, directing the respondent authorities and the petitioner and me, that means the private respondent in that writ petition to be present in a hearing. So, after the hearing was conducted, the matter was sent to the Guwahati University for opinion. So, the opinion was given. But in that writ petition, it was challenged that my teaching experience, is not provincialized. I'm not working under a provincialized government department. So I'm working in Northeastern. I'm working under the Northeastern Regional Language Center at Guwahati, your lordship. It is under Department of Higher Education, Ministry of HRD, Government of India. So because of my experience, under Government of India, this particular impugned this one, after the opinion of the Guwahati University, is impugned at page number 51, Your Lordship. This impugned letter was issued rejecting my this one selection and putting the private respondent in the post of assistant professor at that particular college. So I have approached this honorable court.
Annexure 51, page 51.
Yes, Your Lordship. This is,
Annexure N.
yes, page 51. This is the impugned this one selection. Impugned order is there and the selection list is there associated with that. So where
Where is the select list?
the select list is here only. Yeah. So the relevant portion is at page number 53, Your Lordship. Page number 53, serial number 60. The private respondent is selected over me, Your Lordship. Whereas my marks was higher and I was approved already. That approval has been rejected. I have annexed it. Page number 53, serial number 60, Your Lordship.
Serial number?
60. Page number 53, serial number 60, Your Lordship.
Hmm.
So the private respondent is selected over me. The ground of selection is, Your Lordship, page number 48, Your Lordship, as per the opinion of the Guwahati University.
Page number?
48, Your Lordship.
Yes.
Here it is saying that the teaching experience which I hold from a particular,
Read it, read it.
I'll read the whole, Your Lordship. It's only 2 paragraphs. The second portion I'll read, Your Lordship, second paragraph. The Northeastern Regional Language Center, NERLC Guwahati, Assam is also one of the centers run by the Central Institute of Indian Languages, Mysore. An official letter received from officer in charge, NERLC Guwahati, mentioned that Dr. Kanan Basaman, that is me, has been working as a guest lecturer since 14th July 2017 in the Department of Borough. In this direction, it is important to mention that the guidelines for the selection of assistant professor by notification so-and-so, dated so-and-so, states that marks for teaching experience will be offered only for provincialized government affiliated degree colleges, higher education, secondary schools of provincialized schools. Under this direction, teaching experience in NERLC can be considered for offering marks. NERLC falls in neither any of the above mentioned categories except government. However, it is at your discretion to define the meaning of the government, whether it represents only the state government or both state and central government. So this was the opinion given. The Guwahati University was silent regarding the meaning of the word government, whether it is under the state government or the central government. Now, in this one notification 24(1), let's go back, Your Lordship. Page 43, relevant portion. This memorandum is silent regarding the meaning of the word state or central. I'm under the central government. Relevant portion is page number 43. Here it is mentioned.
Which serial number?
Serial number 8, Your Lordship. Page number 43, serial number 8. Here eligibility is there. Here provincialized is there, and government is there, and affiliated degree college is there, libraries and government institute, higher education, secondary education classes of provincialized schools. These are the eligibility criteria for selection, Your Lordship, one of the eligible as a part of the teaching experience. But here, the Guwahati University is silent regarding the government, whether it's a central government or a state government. Now, provincialized word means concerning the state government, and whereas I am under the central government. But I found a decision of this honorable court, Your Lordship, regarding the nationalization and provincialization. In the last page, page number 67, Your Lordship. some reference might not be analogous to the matter, but in this page, paragraph 32 of page number 67, Your Lordship. Page number 67. In one of the matter, this honorable court defined it. May I be allowed to read, Your Lordship? Page number 67, paragraph 32, Your Lordship. The word provincialization would mean bringing something within the fold of a province. In other words, bringing it within the ownership of the government. Mr. Swensolone, senior advocate for the petition, while making his submissions on this point, submitted that provincialization is not the same thing as nationalization. To us, however, the two substantially means the same, though two are only different to the extent that they operate at two different levels. When the central government brings something within its control and ownership, which earlier was under private ownership, the word that would be nationalization, like the nationalization of the banks in the year 1971. This was done by the center. Similar action at the level of the state, that is a province, would be called provincialization. Naturally, when the madrasas in Assam were provincialized in the year 1995 by a state free freedom as to the payment of taxes.
Yes.
So here in this case, the government, the meaning of the government is silent, whether it is a central
So
government.
you are aggrieved by the select list.
Yes, but the opinion given by the Guwahati University is not decided. But without that, directly my candidate, this one has been rejected, Your Lordship.
Lordship, the experience obtained by the Lordship, the respondent petitioner is from a central government institute, as it is clearly stated by the Guwahati University, Lordship. And so, Lordship, it's not a provincialized college of government of Assam, Lordship. So, Lordship, regarding the Lordship, that experience that can be counted, or I have to obtain
The
instruction.
director of higher education
Yes, Lordship.
was asked.
Yes.
So whether it is government, is state government, or both central and the state
And
government.
provincialization is
That has not been clarified, Lordship. I'll obtain instruction why it has been done, Lordship.
provincialization is same as nationalization.
Yes,
Lordship.
heard Mr.
My name is A. Nazari, Your Lordship.
A. Nazaria.
Prayer before this one for an interim order also against impugn selection.
No interim order at this stage. Will issue notice.
Yes.
Issue notice. Mr.
Yeah,
Tamildar, London Standing Council, Higher Education.
Lordship. Correspondent number 1, 2, and 5.
1
1, 2,
and 5.
5.
Guwahati University.
A. Ahmed.
Mr.
A. Ahmed.
A. Ahmed, London Standing Council, Guwahati University, appears for respondents
3 and 4.
3 and 4. Petitioner to take steps for service of notice on the respondents 6, 7, 8, and 9 by registered post AD within 1 week. Respondents are allowed to file their respective affidavits. This is the matter of the 4 weeks. The appointment of the respondent number 9 shall be subject to the outcome of this.
Obliged.
Highly obliged.
15.
May it please your lordships, case list to compassionate appointment. Lordship kindly turn page 2014, my lord, 2014 minute,
Page.
24/6/2014, page 35. Her name is shown, serial number 5.
1 minute. Yes.
5, my lord. It is stated that the DLC discussed the application for the post of Grade 4 in respect of 13 applicants under DO Bongaigaon, and in consultation with Lordship got it.
Yes.
Gov in Education Department circulation dated 12, where minimum essential qualification for the post of Grade 4 in educational institution and has been fixed HSLC, madam. Then turn page 36, madam. 36. 2, serial number 2. Lordship got it?
Yes.
DLC discussed the application of Mamtaz Begum, found eligible, recommended for compassionate appointment against vacant post 2013 for the post of peon, subject to fulfill all departmental norms rules for the recruitment of Grade 4. My lord.
This is dated minutes.
Minutes dated 2014, 24/6/2014. Lordships. Then Lordship turns 2000. Then your Lordship turn, then page 38, 37, of course. District level selection committee forwarded letter to the director, my lord, and showing the vacancy, everything, my lord, and recommendation, that is 38, page 38. Serial number 2, Mamtaz Begum,
1 minute.
HSLC passed, DLC recommended, 38 Lordships. DLC recommended for appointment compassionate ground as Grade 4 against the vacancy of 2013. Then Lordship turned 39, page 39. It is shown that Grade 4 is 4 numbers of Grade 4 vacancies are there. That is 2015, my lord. It is shown. Then Lordship kindly turned the page 41, and minutes of the compassionate ground held on 25/6/2015, my lord. That minute. Her name is shown as serial number 3. Earlier it was shown serial number 2. Now it is shown 15, serial number 3, Mamtaz Begum. And it is stated that the SLC deferred the selection of Grade 4 staff under Bongaigaon district.
From where?
Yeah, my lord.
Page.
Want of clarification?
41.
41, page 41. There were 4 numbers of recommended candidate and SLC selected both the candidates for appointment of the Grade 4, my lord. Then the SLC deferred the selection of Grade 4, Lordship got it, staff under Bongaigaon district for want of clarification regarding vacancy position to be ascertained by DLC concern, my lord.
Deputy Commissioner.
Yes, my lord. It is deferred. Then I withdraw the petition, my lord, as your lordship's instruction, my lord. Lordships, I have annexed that order because it was deferred, so I have filed a fresh petition. That is last order 53. Petition dismissed on withdrawal with liberty as prayed for. Then lordship turned page 42. That
Yes.
if Joint Secretary to the Government of Assam Elementary Education Department submitted a vacancy position, lordships, by the Deputy Commissioner, lordships, with reference to the cited above, I have honored to submit here with vacancy position of Grade 4 post, DO Bongaigaon for the year of 2012 to 2014 for appointment on competition ground enclosed annexer A as received from DO Bongaigaon for favor of your kind perusal and necessary action. Then your lordship stand, lordships, page 44, where my name is shown and recommended, and vacancy position also shown, my lord.
Page.
In page, my lord, 43, submission of list of candidate for appointment of compassionate ground recommended by the DLC Bongaigaon. Subject, my lord. District Elementary Education, forwarded letter to the Director of Elementary Education, my lord. Page 44, her name is shown as serial number 2, DLC recommended for appointment of compassionate. That is my case, my lord. Lordships, earlier, my lord, Gulapi Das came before this honorable court and obtained order, my lord. May I show your lordships? It is a covered case, actually. It looks. Hey, Gulapi das. I think so. Gulapi das seta udah seta sekali kan. Asal cinta pakai di mana sih agak. Huh?
চাৰিজনৰ ভিতৰত যিটো আছে যে।
Aha. আছে বলে।
এই বস্তু যে
Forty-two feet. Even annex school is forty-two. He is it?
সামিশনৰ ভেকেন্সি পজিচন এনেক্সাৰ এই এনেক্সাৰটোৰ লগত নাই
Annex sir, eighteen. Oh, so just another vacancy.
এইটো 18
So just another vacancy. Oh, I উঠৰত লিখিছে vacancy টো দেখাইছে সেইটো বেচিছতে মই অৰ্ডাৰটো লৈছো মই মিছলিড কৰা নাই দে এই কপি ফৰৱাৰ্ডেড ফৰ ফেভাৰ অফ ইনফৰমেশন ডিও বঙাইগাঁও
When did the SLC defer your matter? 25/6/2015.
15 my lord deferred my lord
After
deferred
this, what happened?
nothing happened my lord that I have obtained this 18 orders my lord in 18 also joint secretary forwarded vacancy position my lord
2018.
18 yes my lord
Who is this vacancy position?
vacancy position lordship lordship kindly peruse the 39 page it is shown that vacancy are there
No.
district elementary
It says enclosed in annexure A.
annexure A my lord
Where is this annexure A?
let them bring instruction regarding annexure A my lord it is not there no my lord I have obtained this one only
I'll get the instruction. Third MSK, they will learn council for the. Mr. J. Beku shall receive instructions, particularly with regard to annexure A. Referred to in the letter dated 27/2008, written by the Deputy Commissioner Bongaigaon and addressed to the Joint Secretary to the Government of Assam Elementary Education Department, whereby the vacancy position of grade 4 post in the office of the DEO Bongaigaon for the year with effect from 2012 to 2014 for appointment on commissioner grounds were enclosed. Stop.
my lord petitioner was recommended for the period of 2013 my lord
Where?
next week my lord next to next week সোনকালে আনাকো 24 my lord 24 or 25 24 my lord 25 এইটো আমি দিছিল দে
Item 10 and 58 of supplementary list.
May I please your lordship, I'm sorry, my lord, even other.
There is an implement application.
My lord,
So what this court is proposing is will implement the party.
my lord,
You file your amended course title.
my lord.
Then after that, we'll
My
proceed
lord.
with the motion.
My lord, I understand, my lord. But normally, my lord, ST may be directed to, my lord, amend the cost title.
No. Now there's a notification.
Otherwise, my lord, 14 is fixed for counseling. My lord. 14 is fixed for counseling.
Item 19,
10.
Alright.
And they were directed to obtain instruction regarding the freedom.
instruction, my lord. My lord, to obtain non-creamy layer certificate, my lord, the income has to be maximum 8 lakhs, my lord. But the petitioner's income is 11 lakhs, 11,000 something, my lord. I have the instruction. So, my lord, To that effect, my lord, I'll file affidavit, my lord.
My lord,
No interim or no.
because my lord, Lordship kindly
Because
appreciate.
If the petitioner is protected, my lord, another eligible candidate will be deprived.
My lord, there is an interim order on in respect of the same subject matter by division bench. My lord, initially there was an interim order saying that, my lord, they should not analyze the matter till, my lord, disposal of the petition, my lord. In my case, my lord, there is a question that my income exceeded the limit, but that was in 2017. 2017, what was my annual income? That should be the, my lord, consideration. Because guidelines says every year they have to revise the, my lord, limit. They did not. Therefore, by that time, my lord, 5 years, my lord, obviously, my salary will be increased, my lord. Because of revised pay scale, because of annual increment. Therefore, that question has to be examined by this honorable court.
What is the income limit of which year?
This is 2017, my lord.
Yes.
Earlier it was 2.5, then 4.5, then 6 and 8. That is definitely now it will increase, my lord, not decrease, my lord.
Obviously, that
So,
suppose,
my lord, that is not a, my lord,
No. But now, has there been any increase after 2017?
no,
no, my lord.
no. Therefore, they have to take into consideration what was my income in 2017, not 2023.
But
That
there is
was
no
at that
mention
time my
that it will
income
be
was 5
increased
lakhs.
every year. It will be changed every 3 years.
They did not.
That it is not here.
National Commission, my lord, National Commission for OBC, they have, my lord, specifically directed and made a recommendation to the government to revise the, my lord, limit. They did not. Therefore, what is the occasion for you to take into consideration my present income? You have to determine the, my lord, eligibility.
So
Okay.
you'll have to take instructions on that issue,
My lord.
not only 2017.
That question I have raised, my lord.
That is the issue that the petitioner has raised. in the-
No, my lord. This notification is from 2017, my lord.
Huh.
In the notification, it is not, nowhere it is mentioned that every 3 years it will be reviewed, my lord. So as on date, my lord, that 8 lakhs will.
Guideline never says, my lord, you have to determine the eligibility criteria on the basis of present income.
Until it is minimized or diminished by another notification, my lord, this will survive, my lord, this 17 notification, my lord.
Income, my income in 2017, 5 lakhs. Much below the, my lord, much below the, my lord, ceiling limit.
What is your income today?
Today is, my lord, 10 lakhs something, my lord, about 10 lakhs.
No.
And 2017, my income was 5 lakhs.
You come with an affidavit.
My lord,
And
You
in
you
that
file
time,
it
some
today.
deduction.
You file it today.
my lord,
We'll take up on Monday because 14th is the day of.
Yes, my lord.
my lord.
Third Tuesday, April Castle and the consequence. Mr. J. Bipul, then a government advocate is permitted to file an affidavit. Considering the urgency involved in the matter, list the matter again on 14th.
Today here, affidavit, my lord, that notification, my lord,
My lord, some protection be given. 14, my lord, if they, Monday.
14 will pass appropriate orders. Don't worry.
14 is, the council will come, will, my lord, will be held on 14.
That's
some
why on
protection
14 morning, first hour will consider the matter pass appropriate orders.
And then if they file affidavit, my lord, then I will have a right to file counter, my lord. That was another problem for me, my lord. Actually, therefore, my lord, let there be a direction in view of the order of the division bench. Let me register with the, my lord, counseling. Let me appear before the counseling, my lord, subject to, my lord, result of this petition. That was the order passed by division bench, my lord.
Yeah, we can give him a provision in
Yes,
subject to the outcome of.
yes,
it.
yes. Let me appear, my lord. Let me take part in the council.
Monday, not even take up that Monday, my lord, not today.
Okay, Monday will pass the order.
My lord. And Monday, my lord, Monday, if they file, my lord, to be frank enough, my lord, if they file affidavit.
Well, even if you don't file also, my lord,
Interest.
Monday, your lordship will take up the matter, my lord. I'll provide sufficient materials, my lord.
This is the only question to be examined by this court. What would be the, my lord, criteria? Whether income of present income or income of 2017. Because it is your failure to revise the, my lord, scale, my lord, the ceiling limit.
Will pass appropriate order.
My lord, my lord. Obliged to.
16.
My lord, page 17, my lord, by this order. Page 17, my lord, 17.
Yes,
By this order, my lord, the school was amalgamated along with my lord Bakhali, Vidya, LP school. Page 17, my lord.
yes,
Thereafter, my lord, the petition, the villagers of the school and the managing committee, my lord, they filed a representation in the next page, my lord. And that representation was attended by the DO, my lord, District Elementary Education Officer. In page 20, my lord, translated type copy, whereby he promised that, my lord, the same will be cancelled, my lord. Thereafter, my lord, as per the page number 22, communication, my lord. Page 22, communication is important, my lord. This is by the District Elementary Education Officer to Director Elementary Education, my lord. Regarding cancellation of amalgamation of merger of elementary schools, my lord. With reference to the subject cited above, I have the honor to require information and ask for that the reference along with minutes of the DLC 5th November 2018, that along with the present school petitioner's school, my lord, for cancellation it was forwarded, my lord. There was a minutes, my lord, minutes I have not received, but as per this later, my lord, page 23, my lord, my school's name is at serial number 1 in the right side, my lord. Name of the school is Samal Dubi. In the 5th column, my lord, the names of the amalgamated school. Our school name is Samal Dubi LP school, my lord. And as per this report, my lord, as reported by CRC of Boginodi, at the time of amalgamation, 57 numbers of students were there, and at present 46 numbers of students in my school, in our school. So there is a pakka building of the school, smooth running condition, and yet not handed over. The school was not handed over till then, my lord. To the end, the school was running smoothly. Students were 47 at that moment. Then there is another communication, my lord, by the DO, page 24. They sought more information, my lord. All these informations were also submitted regarding cancellation and amalgamation of merger of elementary schools. There also it was said, my lord. Here, my school was at serial number 4, my lord, page 24. This was also submitted for cancellation of the my lord, amalgamation. And thereafter also another representation, my lord, another letter, my lord, page 26. Page 26. With reference to the subject cited above, I have the honor to forward here with the updated status report of the concerned schools, 15 numbers regarding cancellation of amalgamation merger on the basis of the field level inspection report submitted by the concerned block elementary education officer. As per the report, it is seen that amalgamation of the concerned schools have been opposed by guardians, but all the schools are not having enrollments of required, although as per the distance is to be looked into as per the guidelines of the Shiksha Kshetra. My lord, our school was page 27 in the top, my lord.
Then what happened after this?
Thereafter, my lord, no action by the director till date. So my prayer is that, my lord, for last 5 years, 4-5 years, the school is suffering. All the students, girls.
Yes,
My lord, here, my lord, I will take instruction, my lord. My lord, another thing is that there is a committee, my lord, regarding amalgamation, my lord. My lord, they have to approach that committee, my lord. That the committee will decide whether
This was of 2018, my lord.
amalgamated or not. No, my lord. It was of 2022, my lord.
No, the
No,
amalgamation.
there was already a proposal. There are already proposals to the director.
My lord, I'll take instruction, my lord. Next week, my lord.
Heard Mr. J. Payal and also Mr.
TK Bora, my lord.
P.K. Bora, Leonard,
Standing Council Elementary Education.
Elementary Education, shall receive instructions with regard to the proposal of the petitioner school. With regard to the proposal for cancellation of merger of the petitioner school, namely Chamardubi,
Somewhat to me,
Bihitia
India LP school
LP school.
at Locking.
List the matter again on when? After a week?
My lord,
After a week.
bless.
Obviously. May.
Yes.
I'm sorry, my lord, I was on leg, my lord. May I please, your lordship? My lord, here is a case, my lord, wherein we have challenged a particular notification, my lord. And my lord may be pleased to find that notification is at page 69. My lord, the grievance which we have raised, that be as per the page 69, my lord, annexure 5. A small part is under challenge, my lord. The language one, my lord has got it, my lord. The conditions of recruitment number 4 mentioned in the advertisement number and so for the recruitment of the regular teachers of the lower primary and upper primary schools under the Directorate of Elementary Education Assam is hereby partially modified in respect of the candidates of the central teacher eligibility test only as the language 1 or language 2 of the CTET qualified candidates shall match the medium of instruction of the school wherein the candidate wishes to apply. My lord, this part is under challenge. Language 2, what the government has done initially in the advertisement, my lord, there was no provision for the central TET qualified candidate take the advantage of the language 2 because, my lord, that cannot be done in view of the, my lord, NCTE guideline. NCTE guideline never gives the, my lord, prescription of law that the language 2 can be applied, can be used at the time of tendering application of the medium of instruction, my lord. So now, my lord, in the meantime, what has happened, my lord, the government has, by virtue of the liberty provided by this honorable court, with a condition that the appointments which are going to be made shall be subject to outcome of the present writ petition, my lord. Now, in the meantime, government has appointed more than 5,600 like this type of person has already been appointed. Now, my lord, when this petition was moved, my lord, on the last time, my respected, my lord, Advocate General has submitted, my lord, that those persons are required to be, my lord, heard as a party respondent in this petition. Now, my lord, my limited submission in this regard today is that, my lord, as we are only agreed with those central TET qualified candidate who had already been appointed by virtue of the language 2, my lord. We do not have any grievance with those persons who has been, my lord, appointed by virtue of the language 1. So now, my lord, how many persons has been appointed by virtue of the language 2? Those persons can only be, my lord, interfered with. Our prayer, my lord, would be that those appointments can only be interfered with because our grievance is not with the, my lord, person central TET qualified candidate who has already been appointed by virtue of the language 1. So, my lord, if the government, my lord, furnish a list or like data, my lord, that how many person has been appointed with the language 2, my lord, then, my lord, we can make a prayer for a paper publication, my lord, for the notifying those persons, my lord, because this will be a huge exercise, my lord, if we are required to make all this person as a party respondent, my lord. That is my humble prayer, my lord.
If that is the prayer, lordship, then I have to take instructions from my department. And that exercise has to be undertaken to find out
Yes.
who have opted and who have got selected on the basis of language 2 paper. So that exercise will need some time.
My lord.
So if lordship gives us 4 weeks time, definitely lordship,
My lord.
we want a fair hearing of the case.
Yes, my lord. Yes.
Mr. A.R. Bhuyan, Leonard Counsel for the petitioner, submits that the petitioners are aggrieved only with the selection and appointment of the central teacher eligibility test candidates who have been appointed on the basis of
Language 2, my lord.
language Roman 2.
My lord.
Stop. He therefore submits that if the list of the candidates who have been appointed, list of the qualified CTT candidates who have been appointed on the basis of language 2 can be given to the petitioners, they would make them parties
Or paper publication.
By way of-
will be made.
by way of substitute service. For Leonard Advocate General, Mr. D. Saike. Prays for 4 weeks' time. to
So
enable-
I am paying for pay, when that is a subsequent, Lordship may have to pass a direction to us. Then only with like, I am not volunteering.
Okay,
Lordship.
okay. In that way of the matter, cancel it, huh? Leonard, who appears? Who is assisting?
P. Bora,
Mr.
P. Bora.
P. Bora, Leonard Standing Council,
Elementary Education Department.
Elementary Education Department is directed to furnish the list of qualified candidates who have been qualified CTT candidates who have been appointed on the basis of
Language two.
language 2 to the Learned Council for the petitioner within a period of 4 weeks. 4 weeks from today. This
Right.
after 4 weeks.
Highly obliged. Obliged.
MS R. Bora, Learned Standing Council, CBSE, appeared for response number 4.
Highly obliged.
Obliged.
May I please, Lordship, here I telling the amalgamation order, my lord.
Where is the order?
Order is on page 15, my lord.
Page?
Page 15, my lord, annexed 2. My school is Lordship, is serial number 30, my lord. Serial number 30, my lord. 30, my lord. Petitioner's school is, my lord, 704 number, Natun Koyakuchi LP school, my lord. I am the president of the school, my lord. My school is Lordship, amalgamated with the nearby Koyakuchi Milan High School, my lord. Lordship, my contention is that, my lord, as per office memorandum dated 3 August 2021, my lord.
Where is that? Where is that OM?
OM is page 19, my lord.
Hmm.
Relevant portion is, my lord, clause 7(1), my lord.
Yes.
This clause is violate, my lord, and also, my lord, clause 13 is violate, my lord. Now, my lord, in our school, my lord, 124 number of students, my lord. And both the school, my lord, situated at the distance of, my lord, 1.5 kilometer, my lord. So, my lord, this both clause are violate, my lord, in this impugned order, my lord. Moreover, my lord,
1 minute.
Koyakuchi Milan High School has no clear ownership of land, my lord. It is situated in a private land, my lord. If amalgamated was done, my lord, the petitioner's school may suffer, my lord. There is a complaint, my lord, in annexure 1, my lord, page 13, my lord, against the Koyakuchi Milan High School, my lord. Regarding, my lord, illegal occupancy of land, my lord. If, my lord, the amalgamation was done, my lord, petitioner's school may suffer, my lord.
Has it been handed over?
No, my lord.
Not yet verse. 17/6/2023 order. This is a dispute with regard to the ownership of land,
Yes, my lord.
with regard to the best school.
Base school, my lord. There is a complaint, my lord. I have the next, my lord, next are one, my lord. It is situated in a private land. my lord.
Dispute it with the ownership of the land.
Yes, ma'am.
You file an appeal
Yes, my lord.
in terms of clause 19.
Yes, my lord. Yes, my lord.
You file an appeal.
Yes, ma'am, may be directed.
Heard Mr.
HL Ashkan.
H.A. Laskal and the counsel for the petition. Stop. Also heard MS N. Fukan, then the standing counsel,
Elementary matter.
elementary education. For the respondents,
1, 2,
3,
1, 1, 3, my lord. 2, not
1 and
I'm
3,
appearing, my lord. 1, 3, 4,
5,
5, and 6, my lord.
1, 3, 4, 5, and 6.
Respondent to SMT 60.
And Mr. SMT Chistil, understanding council secretary education appears to respond number 2. Stop. Para, the petitioner before this court is the president of 704 number Kayakuchi LP School under Barbuta Education Block in the district of Barbuta, and is aggrieved with the order dated 17/6/2023 issued by the
High school level MLA.
Director, Secondary Education Assam, whereby the petitioner school has been merged with the
Kayakuchi Milan High School.
Kayukuchi Milan High School. Correct?
Yes, my lord.
Stop. On the ground that the clause, on the ground that clause 7 within bracket Roman 1 and clause 13 of the OM dated 3rd August 2021 issued by the Secondary Education Department has been violated. Stop. It is the case of the petitioner that the base school is situated about 1.5 kilometers away from the petitioner school, and the petitioner school has an enrollment of about 124 students. Stop. The further case of the petitioner is that there is a dispute with regard to the ownership of land where the base school is situated.
Yes, ma'am.
Under these circumstances, the petitioner is assailing the order dated 17/6/2023. Para. Clause 19 of the OM dated 3rd August 2021 provides for an appeal before the government in the Secretary or Elementary Education Department from any orders for any disputes with regard to any order for amalgamation passed by the director concerned. In that we have the matter, this writ petition is disposed of, directing the petitioner to file an appeal before the Secretary,
School Education Department.
School Education
Yes,
Department
school education.
within a period of
2 weeks. my lord.
2 weeks from today. Now, draft on receipt of the appeal, the Secretary School Education Department shall consider the matter after verification of all records and draft to pass appropriate orders in accordance with law within a period of 2 months from the date of receipt of the appeal. Stop. Till the appeal is disposed of, the merger of the petitioner school with the best school shall remain suspended. Stop. with addition with the above observations.
Most probably.
18,
In this case, Mr. S. Bothago is appeared, he is today not available, I pay for pass for the day.
Next week or any other.
Next week,
On the first matter on behalf of S. Barnable and the council for this list of the one.
Highly blessed.
19,
Item 19, my lord, matter pertains to my lord, compassionate appointment, my lord. What is happened, my lord, in this case, my lord? When the father of the petitioner was died, my lord, he was a minor, my lord. Therefore, my lord, mother of the petitioner made an application, my lord. It page number 18, type copy, my lord.
Page,
Page number 18, type copy. Mother of the petitioner made an application, my lord. Since petitioner was a minor, my lord. In the year 2002, my lord. Thereafter, my lord. Same was, my lord, forwarded to the director, my lord, at page number 23. 23, my lord. There is also type copy, my lord, page number 22. I am directed to forward here the application dated 1/11/2002 from MS Lolita Gogoi, village so and so, which is self-explanatory, and to request you submit the proposal along with the all required documents for appointment under compassionate ground. This is a letter, my lord, in the year 2002. Thereafter, again, my lord, same was forwarded, my lord, at page number 25 to the inspector of school, my lord, seeking, my lord, information and necessary action, my lord. This is also, my lord. Thereafter, my lord, my mother application was remain unattended, my lord, till the year 2014. Thereafter, my mother made an application to the inspector of school, thereby requesting that, my lord, my son may be accommodated to the compassionate appointment, since my application was not considered. My lord, that application is page number 27, 26, my lord, type copy is also there.
was the matter considered by the DLC?
Not considered. My lord, now,
Later it was considered, my lord.
letter issue, it was
DLC considered and recommended to the SLC, my lord.
SLC.
Now SLC said that he was minor at the time of
My lord,
application,
thereafter, my lord, I made
at the time of death. But the mother's petition was not attended, my lord.
attended.
You're sure about that?
My lord, as per this.
But as per the writ petition, that's a different thing, but then as per your records,
My
if
lord,
if the mother's case was considered and rejected,
My lord,
matter ends there,
my lord,
correct?
my lord.
If mother's case was considered and recommended, then what happens?
my lord, may I please listen, my lord, murder case was not considered, my lord, therefore, my lord, DLC has recommended my case, my lord, at page number 37, my lord.
We'll see that.
My lord. I'll obtain instruction, my lord, then.
Page number 37, my name recommended, my lord.
Hmm?
DLC recommended, my lord. Since my mother application was not considered, my lord, therefore, my application is considered, my lord. Page number 39, my lord, 39. 39, assistant teacher at CL number 10, Pulokas Google, that is the petitioner. Now, my lord, SLC rejected, my lord. I was minor. SLC, my lord, will find, my lord, at page number 51. DLC, my lord, well aware of the fact that, my lord, since mother application was not considered, therefore my case has been considered, my lord. Moreover, my lord, there is a letter, my
Where's your
lord,
rejection by the SLC?
my lord, SLC rejection, my lord, at page number 51, 51, my lord. CL number 8, Pulokas Gugui.
Yes, Viku?
My pair is that matter may be here, come back to the SLC again, for test consideration. If otherwise I'm eligible,
The issue is this,
Malak,
your mother's application was made in 2002.
two, Malak,
After that, you kept quiet.
Malak.
Then you made your application in 2021.
No, Malak, 2015, Malak. This is, Malak, that is a reminder, Malak. Case number, Malak, 28, Malak. 15. Subsequently, Malak, this is reminder, Malak. That is reminder, Malak. Case number 32, 21 applications. 15, original is case number 28 in the year 2015, when I am a major. Now, Malak, 21 application is a reminder, Malak.
So for how long were you waiting?
My lord,
You're waiting
my
to
lord,
become a major.
my lord, yes, my lord,
What was your mother doing?
my lord, he went to the office, my lord, they assured that our application will consider, my lord.
Just check up whether the matter was considered at any point of time.
My lord.
At any point of. Heard D. Gogol and Council. Mr. G. Bekul and Governor shall receive instructions as to whether the case of the petitioner's mother was considered at any point of time by the concerned district level committee for appointment on commissioner law. So list the matter after
1 week.
1 week. 1 week.
My lord,
20,
deep level.
My lord, petitioner has challenged the order passed by the director, my lord, regarding rejection of my claim for provincialization.
Where is that order?
My lord, page 93, the impugned order. And before that, my lord, I would like to draw your kind attention that my the petitioner was initially appointed as the founder teacher of Gaurang Tari Feskurmaru Emi Madrasa in the year 1991. Page 32 is the initial appointment order appointed by the managing committee. We also got it. Page 32. 2/1/1991. On the other hand, the private session number 6 was appointed in the year 2008. That is page 36. Page 37, the original, and page 38 is his joining letter. From 1991 till today, he has been serving as the founder teacher of the school. And as per the 2017 Act, page 40, the district elementary education officer of Thubri has submitted the particulars to the director, my lord. Page 40, as a whole, he has submitted the detailed particulars for all the incumbents of the schools. Then page 41, that letter was issued by the director to the deputy commissioner and returned back the proposal submitted by the BO on the ground that the proposal submitted by the district elementary education officer were not authenticated. And therefore, page 44, the deputy commissioner Dhubri has submitted the particulars subject submission of authenticated proposal for provincialization of service of LPUP regarding. Malad, in that proposal, page 46, serial number 6, details of users eligible for provincialization. My name is serial number 6, Eligibility. Subject of social studies. Social studies, madam. Page 48, the original one that was signed by all the members of the district scrutiny committee. But my service were not provincialized, and therefore I approached this honorable court. And the first day, this honorable court was pleased to issue interim order, and against the interim order, page 56, the private respondent has filed the IA. In that IA, he has also annexed a document stating that his name was also recommended by the district scrutiny committee. Therefore, page 79, your lordship order.
Page,
79.
yes.
From page paragraph 3, may I read, my lord? The district scrutiny committee considered the teacher of the said Gaurangtari, Pheskurmari, Emi Madrasa, and thereafter made its recommendation for provincialization of 3 teachers as tutors. In the writ petition, that is my writ petition, the petitioner has annexed the report of the district scrutiny committee at annexer 7 page 24. And the petitioner is shown recommended as subject teacher, social science, along with 2 other persons. The name of the respondent number 7, present respondent number 6, does not figure in the report of the district scrutiny committee. Thereafter, the district director of elementary education issued an order 5/2/2021, wherein the name of one Nur Bahar Ali was provincialized as tutor. Being aggrieved for non-consideration of his case, the petitioner is before this court. Then paragraph 4. The respondent number 7, the present respondent number 6, as applicant has filed IA 32140, that I have annexed, my lord, page. In the previous page, I have annexed that IA 56. Wherein written by as applicant, and in the said IA, the respondent number 7 applicant has also annexed a communication dated 7/9/2021, written by the Director of Elementary Education Assam and addressed to the Senior Standing Council Education Department, wherein it is mentioned that the District Scrutiny Committee Thubri recommended the name of 3 teachers, teaching staff of Gaurangtari Pheskurmari Emi Madrasa for provincialization of service as per Act of 2017. Therein, the name of the respondent number 7 is shown as serial number 2, and the same is annexed as annexer C at page 19 in the IA for vacation of interim order. The applicant further has annexed the report of the District Scrutiny Committee, Thubri, and therein the name of the respondent number 7 applicant is shown recommended for social science subject. After perusing the materials available in the writ petition as well as the IA, this court is found that there are 2 recommendations of the District Scrutiny Committee, one which is annexed with the writ petition and other which is the letter written by the Director of Elementary Education as well as the report of District Scrutiny Committee in the IA with regard to such discrepancy with regard to 2 sets of report of the District Scrutiny Committee cannot be looked into by this court, and it has to be considered by the appropriate authority after going through all the necessary documents and relevant records. Accordingly, the petitioner is directed to file an appeal before the Director of Elementary Education Assam within a period of 2 weeks from today. In the appeal, the petitioner shall annex a copy of the writ petition along with
Yes, I've run through.
Yes, my lord. Then accordingly, I have submitted the appeal, page 83. Then I was directed to appear for hearing, page 89. The first hearing was taken place on 20/10/2022. On that day, I came to learn that my case will be considered favorably because I was the founder teacher. I have been serving for last 32 years, and but the private respondent was a junior, 16 years junior. Then, without passing any order, without cancelling the first hearing notice, the director has call upon me again, my lord, page 90, the second hearing notice. Then again, I appeared before the director on 28/6/2023. My lord, I applied for information regarding the first hearing, and accordingly, I submitted RTI report, RTI application, page 91 and 92. But first hearing report was not provided to me, which was in fact in my favor, my lord. Then page 93, the director has passed the order based on the report submitted in his favor. In the speaking order, there is no whisper regarding the authenticate report submitted in my favor, my lord. And you will also peruse, my lord. The director has considered the report submitted by the
Yes, Fukan.
and therefore I pay for my lord interim protection. My lord.
Should I
Yeah,
take-
notice.
Fine.
In the meantime, that order may be stayed, my lord.
There's no point in staying this order.
my lord. Otherwise, I'll suffer. In the meantime, I have written, my lord.
Have you been provincialized?
No, my lord. At any time, his service may be provincialized, my lord. In my
But
place.
Mr. N. Sharma done constitute of petition. Issue notice. MSN Fukan understanding council. Elementary education appears for respondents 1, 2,
3 and 5, my lord.
and 5. And Mr. Government. J. Bekul and government advocate appears for the respond number 4. Petitioner to take steps for service of notice on respond number 6 by registered post agent within 1 week from respondents may file their counter. This is the matter of in the interim. The impugned order dated 25th July 2023 issued by the Director Elementary Education Assam shall remain suspended till the next.
Highly object.
Item 9.
Made with the lordship. My lord, the matter relates to provincialization of service of a particular school, my lord. Now, what had happened, if your lordship will kindly come to my lord, page number 24, that is the recommendation of the district level selection committee, my lord. Page 24. Name of the employees found eligible for provincialization under section 4(1) of the Act. Now, serial number 5 is my lord Abdul Rashid, that is respondent number 6, and Rahman Ali Ahmed is the petitioner, item number 6. So kindly see, they both were recommended, my lord, as assistant teacher science, assistant teacher science. Am I clear, my lord? Yes. Then please come to the next page, my lord, page 25. Azahar Ali Ahmed, serial number 5. He is respondent number 5, read petitioner, my lord. Sorry, a plaintiff in this suit. And he has been held to be an excess teacher, my lord. Am I clear, my lord?
Azhar Ali Ahmad.
Yes. He is the respondent number 5, read petitioner, and he has been held to be excess teacher. Now, it is a fact that, my lord, in terms of seniority, he is senior. Now, my lord, against this decision, if anybody is aggrieved, if your lordship will kindly have the act, my lord. First, my lord will kindly come to section 17. Page. 1 second, my lord. No, I do. I have appeal to you. Sorry, 14, my lord. At page 123, state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee, and the state government in the concerned administrative department shall be the appellate authority against any recommendation of the state level committee. So, my lord, if you are aggrieved by the district level committee's recommendation, then you are to file an appeal before the state level. If you are aggrieved by the state level decision, then you are to file an appeal before the state government. This is the statutory scheme. Then, my lord, will kindly come to section 19. No suit, prosecution, or other legal proceedings shall lie for anything done in good faith under this act, except with the previous sanction of the state government. To adjudicate dispute of redressal of grievance relating to teaching staff of non-government education institution, as well as dispute concerning disciplinary action, genuineness of etc., 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 there shall be a tribunal for each district within their respective territorial jurisdiction. The district and session judge and additional district of each district
are designated as the educational tribunal. So, my lord, first, if you are aggrieved by any decision, if you are institute a suit or a proceeding before the tribunal, then you have to take the sanction of the state government, something like section 81 CPC, my lord. Now, in this case, my lord, no sanction has been taken. That's the second point. So, on preliminary objection, the my lord, regarding maintainability of the proceeding by the tribunal was under 14 and appeal lie, and under section 19, you have to take approval of the government before instituting a proceeding. Now, let us come to the merits of the case. As far as the merit of the case is concerned, my lord will kindly come to case number 111. This is the regulation for recognition of high schools, high madrasas. Page 111. A regulation for recognition of high schools, high madrasas. Your lordship got it, my lord.
Yes.
Then please come to 113. Subject combination of BSc teachers shall be such.
Where you are reading
I'm
from?
reading at 113, my lord, on top, Roman 2.
Oh.
The subject combination of BSc teachers shall be such that all the BSc teachers taken together shall cover 6 weekly periods in mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology as per section. That means, my lord, these 2 science teachers, they will have to teach 6 weekly periods in mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology. Then, my lord, will kindly come to the next page, 113 towards the bottom, 5, note 5. BSc teachers shall be so selected that their subject combination cover all major branches of science and mathematics. So while, my lord, selecting BSc teachers, regard must be had to the fact that this teacher will be able to teach mathematics, physics, chemistry, physics, and biology. Now, my lord, what has happened in this case, this petitioner is an BSc with royal combination. He has got physics, chemistry, mathematics. Yes, the read petitioner, respondent number 5 is senior most. Second senior most is the respondent number 6. Now, my lord, I have a combination of physics, chemistry, mathematics. Respondent number 6 is a BSc, my lord, with bio combination. That means, my lord, he can teach. He has subjects like, my lord, botany, zoology, and maths. And, my lord, the read petitioner, he has got no combination. His subjects are, sorry, not read petitioner, my lord, the petitioner before the tribunal. His subjects are, my lord, 5 to control. Yes. R5, yes. He is with, my lord, maths, chemistry, and zoology. He has got maths, chemistry, and zoology. Now, my lord, if we go by the seniority, that is the case the petitioner or the applicant would like to contend, then seniority must, under the 2011 Act, my lord, the concept of seniority was there. Now, consciously, my lord, having regard to the SEBA regulation, now this aspect has been done away with the 17 Act. Now, the effect would be, my lord, if supposing based on seniority, respondent number 6 and, my lord, respondent number 5, that is the applicant, is provincialized, my lord, in that case, students will be deprived from physics and biology. That is why, my lord, the petitioner before lordships and respondent number 6 has been recommended. If the applicant is to be given and respondent number 6 is to be given, they cannot both of them teach physics and biology.
So even on merit, my lord, he has got no case. In any case, my lord, how this suit are these proceedings like when you have not taken the sanction under subsection 1 of section 19? It's something like, my lord, section 81 CPC. And my lord, ideally, he should have filed an appeal before the state level committee. Therefore, my humble submission is, my lord, this impugned proceeding is a nullity. It is a void ab initio, my lord, and it should be interfered with. That is my
So where's
submission,
the proceedings?
my lord.
Where's the proceedings?
Yes, impugned order, it starts at page number 77. And the operative portions, my lord, as many as 10 issues were framed, my lord, at page 84. At page 84, lordship will kindly find as many as
The petitioner in this tribunal
Ah.
is respondent number
five.
And the respondent number 6 in the tribunal is
He was 7, my lord. Ami 7 is he? Oh, no, he was 6 before the tribunal also. I was number 7 before the tribunal. My lord will kindly come to 109. Para 31. In view of the discussion of the above issues, I am of the opinion that the petitioner is entitled to decree as prayed for. Upon consideration of the available materials on record of the above decision, I am further of the opinion that petitioner is entitled to decree that he is the senior most science teacher of Bodla Rangapani High School. It is further held that petitioner is entitled to a decree for the cost of the suit. It is further held that in view of the direction and observation of Guwahati High Court in so and so, seniority of are also required to be decreed. My lord, assuming, my lord, there is a decree, what happens? He is senior, so where is the declaration that he is entitled to a decree that his services is to be provincialized? No such decree has been given. He says, we're not disputing his seniority, he is senior. But his subject combination is such, the authority, that's why did not consider him. Well, there is hardly any adjudicative disposition in these cases, my lord. Matter is very simple. If he is given, then the students will be deprived from teaching in, my lord, physics and botany. Biology. My lord, this is not the way to interfere with these decisions, my lord, with utmost respect. Yes, his senior board, his teacher, nobody is disputing, even I don't dispute. But your subject combination is such, you are not entitled to provincialize. That aspect was overlooked by the tribunal, my lord. One second, my lord. Keep it. And my lord will also come to 114 for a moment, my lord. Yes. Kindly come to, my lord, 2 admissible number of teaching and non-teaching staff, 3 class higher secondary high school, 1 headmaster, 2 assistant teacher with BA BCom, 2 assistant teacher with BSc, 1 physics, chemistry, mathematics combination, other with botany and zoology. The event, my lord, the combination of the petitioner and respondent number 5 is also not conducive. Because amongst them, my lord, biology is not there. Supposing, my lord, petitioner and respondent number 5's name would have been recommended. In that case also, my lord, that botany is missing, biology. If 6 and 5 is given, then both physics and biology is missing. It is only when petitioner and respondent number 6 is given, then all the subjects they can teach. That's my humble submission. Therefore, my lord, this order is wrong.
May I please? My lord, I'm appearing for the respondent number 5, the petitioner before the tribunal. My lord, first point, I'd just like to clarify the facts. I was before this honorable court, my lord, by way of petition, assailing the exclusion of my name. This honorable court relegated me to the tribunal. And that is how the tribunal took up the issue. Now, second issue is, if the petitioner wants that his case is to be considered under 2017 Act, I have no objection. My lord will order accordingly. But my case is under the 2011 Act. The 2011 Act, because the proceedings are going on from that day, I am assailing the 2011 Act because our cases were considered under the 2011 Act. So, my lord, if he has any grievance, he has no grievance with 2011, he is relying on 2017, my lord will direct that his case be considered under 2017, and my lord, we will be provincialized under 2011 Act. Now, under the 2011 Act, my lord, it's already judicially held that the only criteria is seniority. I'll place that before your lordship. Once we come under the category, that is, my lord, we are assistant teacher science. That's the category. Within that category, it's only, my lord, the seniority that will matter, nothing else. This combination issue and the recognition issue was an issue before this honorable court in a number of writ petitions. It has gone up on appeal also. I'll place those, my lord. Before I place that, can I have my lord's attention to the rules itself, my lord? The 2011 rules. Page, my lord, it is 653, my lord, rule 4. My lord has 653. My lord, this is the employees to be government servant, rule 4. My lord has got it.
Rule or section?
Section, sorry, my lord, section 4. My lord would just take the trouble of turning it over to section 4.2, my lord. The number of employees in both teaching and non-teaching cadre in each of the venture educational institution services of whom are provincialized or to be provincialized under this Act shall not exceed as specified in the schedule appended to this Act. So for assistant teacher science category, there are 2 posts. Provided that where the number of such employees serving in such venture education exceeds the number as specified in the schedule, the provincialization of services of the employee shall be on the basis of seniority in respective category in the concerned educational institution. My lord has got it. Now, my lord would see here the respondent number 5 had joined on 12/9/96. The respondent number 6 here, my lord, had joined on 24/4/99. And the petitioner had joined on 25/2/2006. When the provincialization exercise under the 11 Act took place, my lord, my name was illegally dropped. Proceedings were there. It then went to the tribunal. Tribunal, my lord, framed 10 issues. One of the issues that was framed and considered was whether the provincialization is to be on the basis of seniority or service, my lord, that subject combination, and my lord, the regulation of the SEBA. These aspects were considered basing on the judgments of this honorable court, wherein this honorable court had said, for the purpose of provincialization under the 2011 Act, the SEBA regulation will have no place. It's only seniority. If that be so, the tribunal has held that it's me. And who is second senior? The respondent number 6, who should be provincialized. And accordingly, that decree came. The relevancy of the seniority is because under the 2011 Act, it's the seniority which determines who will be provincialized. If I can just straight away, my lord has seen that, if I can straight away place those judgments before this honorable court. This is a judgment of my Lord Justice Waipe then. my lord would have para 7. Para 7 would be in the third page, my lord. And these judgments have been considered by the tribunal. The provisions reproduced above plainly indicate that services of teaching and non-teaching staff who have completed 10 years of continuous service in venture educational institutions without any break from the date of recognition thereof and to the date of coming into force of the act, as shall be treated as provincialized with effect from that date. It further provides that in case of teaching and non-teaching staff who are yet to complete 10 years without any break in such institutions shall be also be provincialized from the date on which they complete the required 10 years. However, a restriction is placed by the first proviso thereto, which says that the number of employees in both teaching and non-teaching caste in each of the institutions whose services are to be provincialized shall not exceed the number specified in the schedule appended to the act. Then the second proviso thereto also provides that if the specific numbers of employees, such employees serving in such institution exceeds the number specified in the said schedule, provincialization of the employees shall be done on the basis of seniority in the respective category in the concerned educational institution. The state government disowns any liability so and so. Thus, the crucial words are seniority in the category. For example, if the petitioner is senior to the respondent number 7, 6 in the such category, in absence of vacancy to accommodate both, he will have a superior claim in the matter of provincialization by virtue of seniority. Now, my lord, para 8. When then is the term category? The term category is not expressly defined in the act. In the instant case, we are concerned with the teaching staff of a high school. A clue to the meaning of the term category can, however, be had from the schedule appended to the act. In the second column of the schedule, it is found that all the posts of assistant teacher signs are made to form one category of teaching staff in a high school. Therefore, the term seniority in the category in the context of provincialization of employees of a high school under the Act can only mean seniority among the assistant teacher signs of the school. So read, the respondent number 6 who had joined the post of assistant teacher signs on 27/3/95 in the school is admittedly senior to the petitioner in the category of assistant teacher as later joined on 23/5/98. Now the contention which is being placed before my lord with regard to the combination of subjects. Para 9. It is, however, contended by so and so, learned counsel for the petitioner, that out of the 3 assistant teachers, BSc, the first assistant teacher science, namely so and so, has the subject combination of botany, zoology, and chemistry in BSc. The service of the petitioner, who is a BSc, with the subject combination of physics, chemistry, and mathematics, become essential to take classes in physics and mathematics, which was why he was shown as second assistant teacher at the time of applying for recognition of the school. In my opinion, this contention cannot be accepted for the simple reason that seniority cannot be determined on the basis of the need for the service of the petitioner to teach physics and mathematics. No such provision is made under the Act. There is no dispute at the bar that the respondent number 7 is an assistant teacher science, even though he may be teaching only in advanced mathematics. Once it is held, he belongs to the category of assistant teacher science. His seniority vis-a-vis the petitioner must be determined in accordance with the second provision of section 4(2) of the Act. Since the other respondent is found to be senior to the petitioner, and since there is no other post of so and so to accommodate the petitioner, he has rightly been declared to be accessed assistant teacher. On the other hand, no other issue on the basis of pleadings of the party survives for consideration. My lord, this was the consistent stand being taken with regard to 11 Act. Now, thereafter, my lord will have this judgment, a division bench judgment.
My lord, there is no dispute that under 2011 Act, seniority was the criteria. That I accept.
And we are still under 2011 Act only. I'm not under the 2017 Act. My lord will have the judgment, my lord. Gupen Kakoti. In the school in question, my lord, the third paragraph, my lord. In the school in question, there are 3 assistant teachers, science teachers, and thus, as per provisions of the Assam Venture Education so and so, only 2 science teachers could have been considered for provincialization of their services. Therefore, the 2 science teachers, respondent number 7 and 1 so and so, were recommended, whereupon their services have also been provincialized. Respondent number 7 is admittedly 5 years senior to the appellant. Also, at the time of provincialization, he had completed 20 years of service as teacher, and yet appellant challenged the provincialization of respondent number 7 on the ground that he, being a science graduate teacher with the combination of physics, chemistry, mathematics, same as here, was entitled to get provincialization of the respondent number 7, who, though a science teacher, had a combination of mathematics, geography, and botany. According to the appellant, since respondent number 7 passed graduation in science without chemistry, he could not fulfill the requirement of teaching chemistry to the students in the school. The learned single judge disagreed with the appellant and dismissed his petition. By the impugn order, aggrieved, the appellant has filed the present appeal. Assam venture into so-and-so clearly provides that provincialization of services are to be carried out on the basis of seniority of teachers. And there is no provision in the Act relating to criteria of combination of subjects and science teachers. Moreover, as per so-and-so, under the qualification so-and-so, should be selected so that all the major subjects are covered so-and-so. Anjana Goswami so-and-so as chemistry as one of the subjects. And therefore, she fulfills the requirement of Regulation 5, that is, my lord, in no way disqualifies the respondent number 7 from provincialization of science. I have the subjects which are there. So, my lord, the subject combination is not a issue. It's the seniority that is the issue. Now, if the petitioner claims that his case has to be considered under the 2017 Act, I have no dispute. My case before the tribunal, before this honorable court, is exclusion under the 2011 Act. It's there which I have, my lord, my right which was denied, I am claiming, my lord, which has now been given to me. Now, in terms of the seniority, it's the respondent numbers 5 and 6 who would be provincialized. And that is exactly what the tribunal has. The petitioner is contending basing on the 2017 Act. Fine, my lord. I have no quarrel about that. If he wants to under 2017 Act, he can go ahead. But our cases have to be considered under the 2011 Act, and we have to be provincialized from that paper. This is my case, my lord. So, my lord, the order under which is under challenge before my lord does not call for any interference at this stage, my lord. But that's exactly these two judgments have been relied upon, my lord, at page 105 and 106 of the order. I'm not troubling your lordship. These judgments have been taken into account. Second paragraph of 105, my lord. I'll not trouble with your lordship with that. My lord, the judgments, my lord, would find at 106. And the conclusion, my lord, I'll just have it at 107, my lord. Under 107, my lord, second line. Under such circumstances, I am of the opinion that the submission of the learned counsel for the respondent number 7 cannot affect the question of seniority of the petitioners and so, which is the paramount consideration for purpose of provincialization of the post. With the above observation, the issue number so are accordingly decided. Now, I am back by a division bench judgment also. There are other judgments also on the same line by the division bench and by the honorable single judge. In that view of the matter, this man has suffered a lot, my lord. He is also in the verge of next year also, my lord, he is in the superannuation. He was working in the school from 96, my lord, when the other two were never born in the cadre. In that view of the matter, my lord may examine the issue, but I pray, my lord will not stay or make any restraint on that order, my lord. Because at least from the orders which I have placed before my lord and the interpretation made on the 2011 Act, this is what really follows. This is my humble submission.
My lord, I'll have to reply to my learned 2-3 aspects, my lord.
No, let me just.
Okay.
I'll just take 2 minutes time.
I'm appearing for the lesson number 6, my lord. As a caveat on.
No, 1 minute. Secondary education.
Lordship, here provincialization process was done under the 2011 Act. Moreover, my lord, regarding the government sanction in the trial court or in the written statement, they have never raised such issues, my lord. So, my lord, notice may be issued in this matter and no interference may be called for, my lord. Yeah.
So government is opposing government stand. I understand you appear for the government.
Yes.
So you are objecting to the government stand.
government has want to regularize provincialize me. Very surprising nowadays, my lord.
No, my lord,
You Shama, you better take instructions and come back.
yes, I will take the instruction.
My lord, can I clarify a few position, my lord?
No, clarification, we can take it on Monday. We'll fix it on, let him get the instructions
yes.
by Monday.
For interim orders on Monday, my lord.
or interim order.
Wednesday.
Whatever it is, Monday or Wednesday.
Wednesday.
Oh, interim
My lord,
order.
I'll just 2 minutes, my lord.
Okay.
Number one, my lord, please come to page 35. Sorry. The first, my learned friend has not made any submission on maintainability of this suit. Please come to page 30, my lord. On maintainability, he has not answered the query, whisper made. A suit under section 19(2) of the Assam Education Provincialization Service Act so and so. So if it is a suit under 19(2) for an exercise of power under, under the act, the government sanction is required under 19(1). Where is the sanction? High Court may have said you go to tribunal. That does not mean, my lord, High Court will do away with the procedural requirement. Number one. Number two, my lord, please come to one everman at page number 35.
Yes.
My lord, line about 1, 2, 3, 4, 5, 6, 7, 8 from top. Considering the enactment of the new act and due to inserting of section 19(2) of the said act to resolve such dispute, this suit is filed to address the grievance of the petitioner and to include him, etc., etc., etc. So he proclaims it is a suit under 19(2). If it is a suit under 19(2), where is the sanction? How this suit is maintainable? Merit will come later on. My lord, in Assam, there are at least a few hundred cases in this honorable court where people with the same qualification, they were provincialized under my lord 2011 Act. We all know 2011 Act was struck down by this honorable court. Subsequently, this 2017 Act came in. Now, my lord, there are hundreds of litigations are pending. Earlier, my lord, the same people were under the 2011 Act, they were provincialized as teacher. Now they are being provincialized as tutor. Those litigations are pending. Now, whether your right survived, this is an aspect which is to be gone into. What is the effect of the savings and repealing and savings clause? Well, prima facie, this suit is not maintainable, my lord. How can this order be there? And my learned friend has not made a single argument on that. I started my argument with that. Now, he first must overcome section 19(1). Then only other aspects will come. Therefore, my humble submission is, my lord, either today or some other day, lordship will have to stay this order, my lord. And my lord, otherwise, based on this order, his case cannot be considered.
But Mr. K.N. Chowdhury, Learned Senior Counsel, assisted by Mr.
A. Ali.
A. Ali, Learned Counsel for the petition. Also heard Mr. U.K. Nair, Learned Senior Counsel, assisted by Mr. S. Hazarika, Learned Counsel for the respond number
5.
5. And Mr. D. Gayu, Learned Counsel for the respond number
6.
on request made by Mr. U. Sharma, Learned Standing Counsel, Secretary Education Department. Monday, anyway, this is not a parted matter.
No.
Wednesday, man.
This court will not be sitting, that's all. Doesn't matter. Any other courts will be sitting
Wednesday, madam.
on 16th, to enable him to receive instructions.
And on that day, interim prayer.
The prayer for interim shall be considered on the next week.
Lordship.
At least come with some proper instructions.
No, even if today I am conceding, my lord, if he wants it under 2017, my lord, I'll concede to that. But ours should be left out. He let him have it under 2007. I have no objection.
'54 of supplementary list. Motion.
Wait, please just now. Our petitioner before your lordship is presently working as an assistant professor in Mankachar College. She originally from Saraigaon district, my lord. My lord, what happened, my lord, in this recently, my lord, in the year of the month of June,
2023, an advertisement was issued by the principal of SMD College in the district of Sibsagar. Accordingly, my lord, the petitioner applied for the post as the school college is nearer to her residence. And petitioner is also having an 11-year daughter, my lord. It will be convenient if the petitioner, my lord, gets the job there, get an opportunity. Her candidature was accepted, my lord, by the college. And on 11th, my lord, she was issued a call letter for appearing in the interview. But what happened, my lord? Lordship may kindly come to page 18, my lord. But there was a communication decision from the government. This is dated 14th of June 2022, whereby the government of Assam in the higher education department took a decision that for in-service candidates, no NOC will be required for applying government job. Lordship has got it, my lord. I am directed to inform you that higher education department in partial modification of all earlier orders communications has notified that henceforth teaching and non-teaching staff of all categories of colleges will not require any NOC from concerned colleges, universities, polytechnics for applying for any other post in government organization. However, any inspiring candidate may intimate to the respective college university authorities for his or her applying for any post under any organization, including state or central government. On the basis of this, my lord, while submitting the application, petitioner did not submit the NOC from the authorities of Mankachar College. Subsequently, my lord, when the call letter was issued on 8th, the petitioner came to know that this communication of 14 June 2022 has been stayed by this honorable court in a separate writ petition, wherein the petitioner was also not a party, my lord. That, my lord, lordship will find at page 21. And that communication was challenged by one Dipti Sikha Nath. And that has been stayed by the this honorable court, my lord. The operating part will, lordship will find at page 25. May I read page 25, my lord?
Yes.
In the interim, the communication number so-and-so dated 14/6/2022 issued by the state government in the higher education department regarding non-requirement of no objection certificate from the governing body of a provincialized college by an incumbent serving in the said college for his or her application to any other post in any government organization shall remain suspended until further order of this court. On the basis of, my lord, the college, my lord, is now saying that I have to come with the NOC. On 9th, my lord, lordship may kindly turn to page 26, my lord. I submitted an application immediately on the next day to the authorities of Mankachar College to submit the NOC, but the representation has not been accepted and no NOC has been issued. So my grievance is basically against the principal of Mankachar College, my lord, to issue the NOC, my lord. And as the interview is scheduled to be held on 14th, lordship may protect the petitioner to appear, at least direct the petitioner authorities to appear in the interview without insisting on the no objection certificate, my lord. That is my limited prayer. Otherwise, lordship may also dispose of, my lord, if lordship pleases, if my lord, the other side state is having no.
Yes, Google.
My lord, may kindly peruse page 17, lordship. Page 17 is the advertisement, lordship, issued by the SMD College Sirang Sibsagar, lordship. That advertisement issued, lordship, as per the here date is not there. As per the environment, it was issued on 29/6/23. My lord, may kindly mark it. The date of issuing the advertisement, it was 29/6/2023, lordship. It's in paragraph they have stated in the
Yeah, it is
page
29.
5, page 5, paragraph 4, lordship. They have stated that particular it was issued on 29/6/23. Then my lord may kindly come to lordship the honorable court's order, lordship. Honorable court's order is, lordship, it starts from page 21, lordship, and page 22, lordship. The date is, lordship, 17/3/23, lordship. That particular advertisement was issued, lordship, after passing of the interim order by this honorable court.
The interim order was passed on the basis of that lordship. That particular letter was issued by the concerned authority of the higher education department lordship. That is in page 18 lordship. Page 18. That particular letter was issued by the Commissioner Secretary Higher Education Department by violating the provisions of lordship rule 2010. It's a statutory principles lordship. As per section 24 says that lordship, the governing body is the authority to issue the NOC lordship. By violating the statutory provision, that particular order was issued lordship. So honorable court state the order lordship. And we also admit that lordship, that was in violation of the statutory provisions of the rules lordship. Now lordship, the issue is that lordship, whether NOC is required or not lordship. As per
That
the
is between the petitioner and the school.
petitioner in the college.
Hmm.
Like as per rules lordship, NOC is required. And it should be given by the college authority lordship. GB will be considered it lordship whether NOC can be given or not lordship. There is some reasons is also there lordship. In the particular order itself, it's reflected lordship. Page 23 lordship. Although it is a submission of the petitioner lordship, that is the issue lordship. Page 23 lordship, paragraph 3 lordship starts from the it is submitted lordship. It is submitted by the petitioner that rule 24 of the said rule 2010 empowered the governing body of a provincialized college to decline to issue such NOC if they are of the view that exit or absence of teacher in the college will affect the students and the academics of the college, and therefore it is the governing body of the college only who after due consideration was required to issue the NOC in terms of rule 24 of the 2010 rules lordship. There is a reasons lordship. It is the absolute discretion because lordship advertisement has issued lordship. There is a financial burden also there lordship. Student, we have to look after student also lordship. So if the college is not able to issue the NOC lordship, then it cannot insist. We cannot insist us.
I'm not insisting the state, my lord, for issuance of the NOC.
But
Lordship may
college-
kindly turn to rule 22, 24 of the, my lord, Assam College Employees Provincialization Rules 2010, my lord. If
Page-
Lordship is holding the same book, my lord, then it is page 504.
Yes.
Lordship has got it, my lord. The language is very simple, my lord. The governing body shall issue no objection certificate to the college employees for applying for admission to courses of higher studies and for other jobs. The language used is that there is no discretion. If Lordship goes by the language of the rule, there is no discretion is vested on the governing body to deny the no objection certificate. It is the duty, statutory duty of the governing body. If NOC is sought for, my lord, by a particular candidate, it has to be issued. But denying that, my lord, the college authority has violated this statutory duty imposed upon the governing body, my lord. But on Monday examination, the interview is scheduled, my lord. Lordship will kindly come. to
Why
page-
are you coming so late?
My lord, on 8th, I was issued the call letter. Lordship will kindly come to page, my lord. Page 20, my lord. On 8th, call letter was issued, my lord. Immediately on 9th, I submitted an application. College has not received the application also. That statement is specifically there, my. Page 20, regarding interview for the post of assistant professor in the Department of History, STP in SMD College, Saring, Sibsagar, dear candidate. So it was issued to the petitioner, my lord,
Okay.
on 8th.
Third, Mr.
T. Chakraborty, my lord.
T. Chakraborty, Leonard Murphy. Para. The petitioner is presently working as assistant professor in the Department of History in Manpacha College, South Market. Stop. Pursuant to an advertisement dated 29/6/2023 issued by the principal SMT College Charing. The petitioner met her application in respect of the against the post of assistant professor of history in SFT College, Charing. Stop. Where's that Paul letter?
Lordship, call letter is at page, my lord. Page 20, my lord.
Thereafter, the principal in charge, SMT College, Charing, issued the call letter to the petitioner on 8/8/2023. Where's the issue of NOC here?
Wait, here it is not written, my lord. In the advertisement, it was mentioned, my lord.
To appear before the selection committee on 14/8. It is the case of the petitioner that she has applied for NOC to the principal cum secretary, Mankacha College, South Salmana, for issuance of a NOC on 9th of August 2023. Stop.
See, advertisement is page 17, Lordship. It was reflected there, NOC is required, Lordship, and that particular advertisement issued on 29/6/23, Lordship.
On top pursuant to so and so. Just say, during in the said advertisement, it is provided that candidates that in-service candidates must apply through proper channel with NOC obtained from the competent authority. Then come down. What do you say? Petitioner applied for the NOC on 9th August 2023 before the principal cum secretary, Mankacha College, South Surrey. However, his application has not been accepted,
Has not been accepted. my lord.
and NOC has not been issued till date. Stop. Learned counsel for petitioner submits that in terms of Rule 24 of the Assam College Employees within bracket Provincialization Rules 2018, the governing body of the college is mandated to issue no objection certificate to the college employees for applying for admission to course of higher studies and for other jobs. Accordingly, issue notice. Mr. K. Gogoil and Standing Council, Higher Education,
Lordship, I am representing 1 and 2.
appears for the respondents, 1 and 2.
Lordship.
Stop. Petitioner to take step for service of notice on the respondents 3, 4, and 5 by registered post ID within 1 week from today.
My lord.
Stop. This is the matter of the 4 weeks. In the interim, it is directed that the petitioner shall be permitted to appear in the interview for the post of Associate Professor History for the SMD College, Charing, even without NOC. Stop. However, there shall be no finalization with regard. No. However, the respondents are directed not to finalize
Lordship,
the selection process.
instead of that, Lordship may indicate that her appearance before the interview is subject to the outcome of the reputation. Otherwise, Lordship, if she is selected, then she will get the job. And otherwise, if she
No,
other
if
person
she's
is
selected and she gets the job and this writ petition is dismissed, then what happens?
so Lordship may indicate subject to the outcome. If she is not selected, other person will be selected. Then college will deprive that particular college is deprived, Lordship. So Lordship may indicate subject to outcome.
However, the result of the selection with regard to assistant professor history of the SMT college Jari shall be subject to the outcome of this request.
And the plea applies.
Lordship, instead of result, Lordship, the candidates of the petitioner, Lordship.
Huh.
Lordship, immediate candidates of the
The
petitioner.
candidature
Oblige, Lordship.
55,
Timing question? Timing question?
May I please, Your Lordship?
yeah.
My lord, the Guwahati University, my lord, has time to time, my lord, fixed the different system of, my lord, and pattern. Pattern as regards the, my lord, undergraduate, that is the graduate degree course. Initially, my lord, it was 2+1. Then, my lord, it was converted into 1+1+1 course. Then, my lord, it has now been converted into the semester system. Now, my lord, as regards this system, we do not have any grievance. But, my lord, the system of marking, which has been, my lord, upgraded from time to time to, my lord, fit with the modern education system as well as the national education policy. They have also, my lord, upgraded the system of the how the marking pattern is required to be given. Now, my lord, in our days, my lord, when we appeared in the undergraduate courses, my lord, it was a straightforward system, my lord, that if a person out of 500, my lord, secured 300, then his percentage would be calculated in that manner that he is securing 60% or 70%. Now that system, my lord, has was continuing till, my lord, 2013, and from the year, my lord, 2013, 2003 to 2013, that system was going on as the absolute marking system. Now from, my lord, 2014 to 2018, they have, my lord, evaluated another policy, my lord, absolute marking as well as the CGPA, that is, my lord, non-conversion of the, my lord, cumulative grade point, my lord, average point in the marking system, that if a candidate, my lord, has secured a percentage is given, my lord, that 10-point system is there. If he secured, my lord, 8.5, basing on that, they uses to gives the marking system. So, my lord, what has happened? We are agreed with an impugn notification, my lord, has recently been published by the Guwahati University. My lord, may straight away can come, my lord, to the impugn notification is at page 26, my lord. It is notified with the approval of the honorable, my lord has got it, my lord. It is notified with the honorable Vice Chancellor, Guwahati University, for all concerned that the academic council meeting, the wide resolution number so and so, resolved that for the non-CBCS UG course, the conversion of CGPA to a percentage of marks has been approved as CGPA into 10, and in comparison with the absolute marks, it is resolved that whichever is higher will be considered. Now, my lord, what has happened? Those candidates, my lord, who has passed after the 2013 to 2018, they have, my lord, in their mark sheets, both systems were available. That is, my lord, absolute marking system as well as, my lord, the my lord, CGPA system is also there. Now, as per this notification, my lord, what the Guwahati University has decided to do, that, my lord, both the marks will be calculated in the in both pattern, that is in the absolute marking as well as in the CGPA pattern. Now, if the CGPA pattern, my lord, gives the higher percentage of marks for the both for the one candidate, my lord, then the CGPA will be counted and the absolute will be discarded. Now, the difficulty for the candidate like me, my lord, what has happened in my mark sheet, as I have passed out in the year 2011, 2013, my lord, in my mark sheets, there was no CGPA system has been, my lord, incorporated at that relevant period of time. So therefore, my lord, now I am required to compete with the candidate who having, my lord, double force in their mark sheets, my lord, CGPA as well as the absolute marking. Now, my lord, I do not have the CGPA, so I am compelling to make a competition with those candidates who has the CGPA as well as the absolute marking, my lord. That's the my lord, discrimination comes, my lord. Now, my lord, my grievance is that government can, my lord, formulate a policy, or the university has the power to formulate a policy. But my lord, my grievance is that once the category of the of my nature, my lord, that those who has the absolute marking system in their mark sheets, they should be categorized in the one pattern, my lord, and the CGPA can be complete with the CGPA, my lord. We do not have any grievance on that. Now, the CGPA system, my lord, kindly see, CGPA, if 8.5 somebody is carrying into, my lord, into 10 is there, then he will be getting, my lord, 85%. But in the absolute marking system, it is not possible, my lord, to score so much of higher marks. So automatically I will be ousted, my lord. I have been created a different class from the same class of people, my lord.
Yes,
First of all, Lordship, it's a academic analysis. That totally expert. This issue is, Lordship, the academic issue, Lordship. It's expert issue. As per my humble submission, so with apology, the Honorable Court under 226, Honorable Court has no jurisdiction. Honorable Court is not expert, Lordship, regarding the academic. It is reiterated by Honorable Apex Court time and again, since Devendra Bhaskar, Dahir Ahmed Khan, lastly, my Lord Justice, Lordship, my Lord Justice Dipankar Dutt also, Lordship, three judges bench says that, Lordship, when academic matter is there, the Honorable Court should restrain to interfere. First of all, it is my first submission, Lordship. And other thing also, Lordship, regarding that CGPA part and Lordship, other part, Lordship, my Lord may kindly peruse page 23, Lordship. There is no any violation, no any discrimination to any other candidate, Lordship. The government has already taken care of that part also, Lordship. My Lord may kindly come to page 23, Lordship. 23, Lordship. The head is marking for academic records will be calculated as mentioned below, Lordship. It is a rationalized process by the government of Assam, Lordship, not depriving anybody, Lordship. So my Lord may kindly come to first column, Lordship. Lordship, it's a 85% and above, Lordship. It's a mark is 9, Lordship. 85 to 100, Lordship. It has taken as a one category, Lordship. Then, Lordship, not only my Lord may even one person, Lordship, get 85%, Lordship, and another person get 100%, Lordship. They are equalized, Lordship. Because Lordship, CGPA, Lordship, the marking pattern is high, Lordship. The percentage also high, Lordship. We also that Lordship, not CGPA. Lordship also that the conventional procedure is there in our days, Lordship. Nowadays, CGPA is there, Lordship. CGPA mark is, Lordship, admittedly high. So what government has done, Lordship? Government has categorized, Lordship, one, Lordship, at a gap, Lordship, up 85 to, Lordship, 10. 85 to 100% is a one category. Then, Lordship, 75 to 85% marks, Lordship, as a one category. Then 65 to 75% one category, Lordship. 50% to 65% is a one category. And less than 50% is a one category. So there is a rationalization, Lordship.
we'll issue notice.
Lordship will issue notice, we'll clarify it.
My lord,
Otherwise, also, so
We are not responsible.
my lord, my limited prayer, my lord, so with regard my respected friend submission, my lord, we do not have also any objection with regard to the CGPA. But only problem, my lord, may kindly appreciate, my lord, in my mark sheet, there is no CGPA marking is there. But now I am going to compete with the person, my lord, who has the CGPA as well as the absolute. Now, my lord, as from the mouth of my senior, my friend has fallen, my lord, that the CGPA is always carries a higher marks. Now, my lord, once the CGPA is going to be given the advantage as per the impune notification, my lord, then obviously, my lord, we cannot be treated as equal. That is our grievance, my lord. That's come the discrimination, my lord.
that's why rationalization page 23.
No, that rationalization process,
rationalization
that,
is
my lord, in my case, that rationalization is not going to be applied, my lord.
Mr. K. Gogol, and it's Standing Council Higher Education, appears for respondents 1 and 2. And Mr. PG Fuka, the Standing
3 and 4.
Council, Guwahati University, appears for respondent number 3 and 4. Notice on respondents are complete, however, extra copies.
My lord.
Respondents are allowed to file contract. Please. Progress.
My lord, this subject to outcome observation may be given, my lord. The process.
That is automatic, that goes
No,
without
my lord,
saying.
if that observation is not given in future, my lord, some difficulty is there, my lord. That observation will not make.
What
any difference.
observation, Lordship?
Nothing, it will make-
Nothing is there, Lordship.
No, no, my lord, my submission is that. my
Whether
lord,
they have challenged the Lordship particular when,
Okay,
Lordship.
okay. The notice dated 9/6/2023
My lord,
issued by the Controller of Examinations, Guwahati University shall be subject to the outcome.
my lord.
What difference was it make, Mr. Bhuyan?
My lord, my case, my lord, my repeat, the appointments, my lord, which were made prior to that, my lord. This honorable court has held that there is no any such observation. Now you have to, that is the issue, my lord, sometime arise, my lord. Oblige, my lord, oblige. my lord.
56.
Oblige.
Yes.
My lord, I, first of all, before I proceed, I only would say, this is how sometimes the litigants are dragged before this honorable court. This is the prime example. My lord, 6 persons were recommended by the district scrutiny committee. It was sent before the state level scrutiny committee for necessary approval and approval of the government. Out of the 6, they have given 5. They did not give 1, that is left out. 5 got job, including me. The 6th person who was left out, he approached this honorable court, saying that he did not challenge the science teacher, other 4 teachers he has challenged. When the matter was before this honorable court, a citation was produced before this honorable court saying that under the RT Act, it was mentioned from 91 to students from 91 to 120, there should be 4 teachers, but that school, the citation which was referred in the court, in that case, but that school had only 3. So director was given a direction. You please examine this, and if additional post is created or given, can that petitioner be considered against that post? When our case was before my lord, before this honorable court, that citation was placed before this honorable court. And the petitioner's counsel also informed the court that at present there are 236 students. So 236 students under the RT Act, the ratio 1:35 goes to about 8 teachers. And original, when the 6 was recommended by the district scrutiny committee, that was also following the RT Act. When the court realized that earlier this honorable court has taken a stand for creation of a additional post. So in this case, when the pupil teacher ratio goes to show that another teacher can be accommodated. So without going into the merit of the writ petitioner as well as those 4 respondents, private respondents, including me, ask the director, you please examine the matter to, if you can create an additional post and whether that writ petitioner can be accommodated again against that post. The surprising 1-sentence order is theirs. Instead of accommodating the writ petitioner by creating an additional post, what the director has done, he has reduced another post, and that is me. And interesting over here, I don't know how me, because we 3 among those 4 private respondents in the earlier proceeding were appointed on the same day. Now I'd like to bring your lordship attention to the honorable court's order directly. What was the director was asked to do and what the director has done. Malad, I would like to bring my lordship attention to page 32, annexure 5 first.
Yes.
My lord, next page, page 33. Would my lord has seen serial number 6269.
Yes.
My lord, I am number 9. These are the 4 private respondents in that writ proceeding. My lord, then when the petition was, if your lordship looks at paragraph 4, that is 35. May I read, my lord?
Let's see the operating portion of it.
My lord, operating portion, now would your lordship be pleased to see 6 ones?
Yes.
This is important. In the alternative, it has also been submitted that this court in the case of so-and-so, which I referred before, my lord, this was the paragraph 6 of this writ petition, my lord, which was earlier decided. In view of the above, the writ petition is disposed of with a direction to the Director of Elementary Education, Assam, to examine the aspect as to whether the Biraj Mohan Kumundi Datta MA school has number of students between 91 to 120, and if yes, as to whether one additional post of teacher can be provincialized over and above the 3 teachers who were provincialized under section so and so. Well, the next, the requirement of the director to examine and pass a reasoned order be done within a period of 2 months from the date of receipt and certified copy of this order, my lord. Now, in our case, my lord, paragraph 9. My lord, the operation part is last 4 lines. If the director arrives, my lord, got it. If the director arrives at the conclusion that the school is entitled to 1 additional post of teacher, he would further examine as to which teacher of the school is to be provincialized against the additional post, and in doing so, the case of the petitioner shall also be given due consideration. Now see the interim impugn order. Page 40, my lord. My lord, one thing your lordship would see, it is very cryptic and 1 sentence order. In compliance of the honorable court's order dated so and so, and based on the report of hearing dated so and so, in respect of so and so, Musharraf Hussain versus so and so, earlier repetition, the service provincialization order issued by DE Assam by number so and so, dated so and so, in respect of Abdul Karim Mullah, tutor of so and so school under Gauripur Education Block of Dhubri district, is hereby cancelled.
It is 18 July 2023.
Yes.
order.
I've already said I received it on last Saturday.
Last Saturday.
Yes. That's the reason your lordship allowed this writ petition to be listed today. I mentioned it before yesterday.
You issue notice. Heard JRB Planning Council.
And final detail affidavit.
Well, Lord,
Issue.
I think this order should be stayed.
Lordship, at this stage, Lordship, it should not be, Lordship. I have
Mr. Furqan,
Then your lordship may reject.
Standing Council.
the report will be required.
No, no, the
Lordship.
High Court did not ask this. High Court.
Passing orders.
Yes.
Please keep quiet. Then the Standing Council Elementary Education. Appears for respondents. 1,
1, Lordship, 1, 2,
3,
1, 2, 3, and 5.
and 5.
Oh, my lord, my.
Mr.
Well-
Dear people, then the government input appears for respondents. Notice on respondents are complete. However, extra copies. Respondents are allowed to file comment. List of the forwards. In the entry, the order dated 18 July 2023, by which the provincialization of the petitioner was cancelled. 18 July 2023 issued by the Director Elementary Education, Assam, by which the service provincialization of the petitioner was cancelled. Shall the next in the next statement.
Deeply obliged.
So I need 1 week time because he's saying that impugn advertisement was already been cancelled. So I need some time to confirm it.
Yeah, Mr.
Ananupati.
On request made by Ellen Upadhyay and then a conflict of the petition. When do you want?
1 week again.
It's on 22nd, my lord.
After 1 week.
I'm for the, my lord.
Mr. S.K. Mehdi, you're the
I'm for respondent number 2 and 3.
council appears for respondents to
2 and 3.
Public.
57 of supplementary list.
Wait, please, Your Lordship. Yes, please. My lord, this case also pertains to EWS, but no relation with the other dispute, my lord. Here, my lord, what has happened is that the selection list, my lord, which is really at page 57, if Your Lordship sees, my lord, but the petitioner is an EWS category candidate, my lord, who appeared for the MBBS first year examination under NEET UG. Your Lordship kindly comes to page 57. That is the impugned selection list, my lord, for the MBBS first year. Now, Your Lordship will kindly take up the serial number 1, my lord. If we see the candidate, my lord, who has the serial number 1, revised state rank 5, he is from the EWS category. My lord, if Your Lordship sees, my lord, in the after 2 columns, my lord, he has been adjusted in the UR, that is the unreserved or open category, my lord. And he has got, my lord, Guwahati Medical College. In other words, what it means, my lord, that though he belongs to the EWS category, he has been adjusted under the UR or open category, my lord, because his merit has propelled him into that, so he is considered under that, my lord. Now, there are so many other this EWS candidates who, on the basis of their own merit, my lord, have qualified. Your Lordship comes to the very next page, my lord, page 58. Lordships will see, my lord, that at serial numbers, for example, my lord, 29, my lord, this is also, my lord, an EWS candidate. He has scored 643. On the basis of his merit, he has also been adjusted under the UR quota. Same is the case, my lord, serial numbers 30, 31, 32, 34, 35. So all these are, my lord, EWS candidates who, on the basis of their high marks, my lord, their merit, that is, they have been adjusted under the UR quota, my lord, which is the law laid down by the Apex Court and this court, my lord, that the open category, the reserved category candidates have to be adjusted. If they are meritorious, they have to be adjusted in the open category, my lord. Now, if Your Lordship, my lord, I may take Your Lordship to page number 66, my lord.
Yes,
Lordship will find at the bottom of the page, my lord, serial number 220.
yes.
220, my lord. This candidate, Priyankar De, he has secured, my lord, 594 marks. He also belongs to the EWS candidate, the EWS quota, my lord. And he is the first candidate from the EWS quota who has been adjusted under the EWS quota only. So the quota is mentioned, my lord, EWS, not UR, my lord. So he is the first one from this EWS who has been adjusted in the same quota. Now, my
How
lord,
about the others? Serial number 200, 201.
200, 201, they have, if Your Lordship sees, my lord, they are all under the UR. My lord. For example, serial number 200, he has got, my lord, 597. He is EWS category, he has got under UR, he has got Dhubri Medical College. Similarly, my lord, 201 also, he has got 597. He also got, my lord, adjusted under the UR. So on the basis of their merit, they have been adjusted in the UR category, which is the law, my lord, that they have to follow the law. But starting from this serial number 220, as I pointed out, my lord, this candidate has been adjusted under the EWS quota, though he has got 594. Now, my lord, Your Lordship would permit, my lord, page number 70, my lord.
Page?
70, 70, my lord. My lord, Lordships will come to, my lord, serial number 297. Again, my lord, 582 marks. He has been adjusted under the EWS. Serial number 298, he has got 582 EWS candidate under the EWS. Serial number 303, my lord, he has got 582 again under EWS. So, my lord, this continues. And, my lord, the last candidate who has been adjusted in the EWS, my lord, he, or rather she, my lord, is at page number 76. Page number 76, my lord. This is serial number 425. Lordships have serial number 425 minutes. Lordships will see that, my lord, the score is 568. Jhalak Jalan, she is EWS, and under this she has been accommodated in EWS quota. She has got the Tezpur Medical College. But hereafter, my lord, the EWS quota ends. No other candidate has got EWS under the EWS quota, has got admission in the MBBS course. Dental is separate. I am not on dental, my lord. Under the MBBS course, no other candidate has got under the EWS quota.
Whereas your lordship will see prima facie, my lord, that the UR candidates are continuing to be adjusted in the UR. And the UR quota, my lords, is finally exhausted in the sense that the cutoff, my lords, if I may take your lordship to page number 83, my lords. Page number 83. And the serial number would be, my lords, 591. This candidate has scored, my lord, 552. She is also a candidate in under the EWS, but she has been accommodated under the UR. She has got Kokrajhar Medical College. And my lord, she is the last candidate from any category who has been adjusted in UR. So, my lord, the quota in UR quota ends here as far as the MBBS concerned.
Serial number to
Serial number to hold 591. 91. So, you know, what has happened in very simple words is that the cutoff for the EWS has gone up to 568. And the cutoff for the general or UR category is, my lord, 552. My lord, it's like saying this, that let us say, my lord, the general category, my lord, cutoff is the last candidate on the general category gets 100 marks. But the EWS candidate has got 105 marks, and he has been converted into he has been converted under the EWS quota. The law says, my lord, that if the last candidate under the UR category gets, let us say, 100, then all the other candidates, my lord, if somebody is whether from SC, ST, OBC, EWS, because these are, lordship knows, my lord, vertical reservation. In a case of vertical reservation, my lord, the line has to be, if they are meritorious, they have to be above the general. If he gets more than the general cutoff, then he's meritorious, he is entitled to be selected on his own merit. The only caveat is that he will be adjusted under the UR quota, but his choice as far as the institution, or let us say in this case, the medical college, his choice will be, he will get the institution of his choice. Because as far as choice is concerned, he will get the benefit of his quota, but the adjustment will be under the general or unreserved quota. So that this is to, what is the purpose of these quotas, the vertical reservation, EWS, SC, ST, OBC, it is to pull somebody up who is below, to give him that fair play, to give him, put him on an equal bargaining position. If he is already getting 105, then there is no question, of pulling him up, because he is already there on the basis of his merit alone. Now, the Supreme Court, right from the days of Indira Sani and right up to 2023, 13 of judgments has held that any candidate belonging to any reserve category who scores more than the last qualified general, he has to be adjusted in the open category, but he has to be given, the institution or college, in this case, of his choice. For example, let us say that there is a candidate from the ST category. He is scoring, let us say, 110 months. That is above the general cutoff of 100. He will be adjusted, in the unreserved category, but at the time of choice filling of his admission, he will be asked his preference. So that if he gets, let us say, Guwahati Medical College, he will not be told, no, you have got under the UR, so you go to Dhubri or to Kokrajhar or Diffu, which are the, let us say, not so preferable colleges. So he will be entitled to his choice under the quota, but his spot in the quota will be taken by the next, least meritorious, the other candidates in the reserve category, whether it is SC, ST, OBC, or in this case, EWS. Now, if your lordship, this continues, and if your lordship comes, what happened in the year 2022? How did they deal with this situation in 2022? Your lordship comes to page number 172. 172, Annexure 7.
Yes.
Like your lordship sees, at serial number 3, the candidate in last year scored 666. She was also from EWS, and she was rightly adjusted under the UR because of on the strength of her merit. Same is the position at the candidates, let us say, serial number 13, who has got 643, serial number 14, 642, serial number 19, 636, 20, they all got same marks, 636. So, last year the position was, correct, this is the way of preparing the chart that was followed in the year 2022. And, what has happened last year is that the first candidate from the EWS who was adjusted, under the EWS quota after the UR quota was finished. My lord. Now, Your Lordship will. Yes, Your Lordship will kindly come to page 190. my lord. 190, 190. My lord.
Yes.
My lord, serial number 400. My lord. Lordship will see, my lord, that score was 548. And this candidate, my lord, also from the unreserved category. She was the final candidate from the unreserved category who was accommodated in any medical college. So after her, my lords, the EWS candidates started. The first EWS candidate, my lord, is at serial number 407, my lord, of the same page, my lord. On the same page, 407, he scored 547 marks, which was, my lord, 1 mark less than the last UR candidate. And this candidate, my lord, Jahid Hassan Barbuya, EWS, my lord, he was the first candidate to be accommodated under the EWS quota. And he was given Defu Medical College. And thereafter, my lord, at serial number 413, 415, 16, 17, 18, all of these are EWS candidates who were rightly accommodated under the EWS quota. So that means, my lord, once the UR list is finished, the UR candidates are exhausted. Thereafter, the reserved categories begin, so that the other candidates in the line from the reserved categories, they are not deprived. Because as I said, the one who is already on top, he doesn't have to be pulled up. He is already there. He has already taken his place on the strength of his own merit, his or her own merit. But the one who has fallen behind, he is to be pulled up. He has to be accommodated. He needs, my lord, the benefit of the vertical reservation, whether it is SC, ST, OBC, or whether it is EWS, because all these are vertical reservations. So, my lord, these candidates have to be accommodated. If anybody is qualifying on the strength of the merit, all those have to be accommodated under the UR quota. And once that is done, my lord, the next person in the line, my lord, takes his place. Now, in 2023, what has happened? Every candidate, all the 60 candidates who are EWS candidates, who have qualified on the basis of their own merit, they have been accommodated under the EWS quota. As a result, my lord, the EWS cutoff finishes at 568, my lord, whereas the general cutoff, the unreserved cutoff, finishes at 552. Now, this is an unthinkable, unheard of position anywhere in the country. This is impermissible constitutionally. And as I said, my lord, that if the general cutoff is lower, then, my lord, there is no purpose of reservation because these candidates are already there. The only benefit that they will still get is that they will get the institution of their choice, whereas the next in the line candidates under the reserve category, they will not get that choice. They will be allotted wherever seats are vacant. That is the case, man. Now, as far as subject to whatever my learned friend says, there is case law on the subject. The lordship, my lord, addresses.
Regarding the procedure adopted, there is no quarrel, that EWS candidate, if he scores higher marks, he will be accommodated in the unreserved category, but he will get a choice to have a college of his choice. And in that case, if a unreserved category candidate like the EWS who has got a seat in as an unreserved candidate, that seat will be again converted to unreserved, so that the unreserved is maintained and the EWS is also maintained. Here, regarding this cutoff, nowhere in this particular bunch of chart that has been placed, it has been mentioned that for EWS the last candidate selected is 568. And for unreserved, it is 552. It is their own presumption, So on this regard, let me have the inspection.
When is the admission?
The admission is going on. It is going on. The first round is complete. And
to my knowledge, whatever I have from the Director of Medical Education today morning, they have been following the same principle as has been stated by my friend, following the judgment of the apex court, and it is there in the rules of 8C is the provision. But let it be taken up on Monday, considering the urgency.
Monday?
Yes, I will place it.
But since it is only one seat,
candidate is there, he will be, he will have to leave, he will be accommodated. That part, not worry.
I'll just rejoinder to my friend. What is going to happen, my lords? In case the list has to be recast, because this is against constitutional law, subject to whatever my learned friend may bring, any affidavit, any instruction, anything he may bring, but this is constitutionally impermissible. We are absolutely clear on that. what has happened is that 60 candidates, all EWS, they got under the EWS quota. Now, they will be adjusted, they will have to be adjusted under the general quota, the unreserved quota. Naturally, my lord, there will be a displacement of the UR candidates. And because, my lord, the other 60, the next 60 in the line of EWS, they will have to be accommodated. But that, let me come to it. But I am not on the issue of how many have to be accommodated, but the petitioner is 45th in line. So if, my lord, 60 have to be accommodated, then naturally I can be considered, because then I will become eligible. Because then, my lord, what will happen is that the EWS last cutoff will fall below the general, as it should be. So then I will be eligible, I will be in the fray. Another aspect of the matter which I have addressed in the writ petition is that, my lord, the NRI quota which they have given, 88 seats, only 33 have been filled up and 55 seats are vacant. So the general category candidates, even if they are displaced, they can be considered under that quota also. Nobody stands to lose anything. What they have done is apparent on the face of the record. There are no two versions of this, no amount of improvement. What I'm saying is that, my lord, to protect the.
Are not there. Let it be on Monday. I will have the.
Mr. B. Gogoi, Leonard Standing Council, Health.
Help.
Shall receive instructions in the matter. Is the matter 14.
No, the interest of the petitioner may be protected, my lord.
So we'll consider on the 14th. Prayer for interest shall be considered on the next.
21 of daily list, the vacating application.
May I please, your lord? In this case, my lord, last time status report was called from the DC office. And I would like to mention 2 points, my lord, regarding this issue, my lord. The name of the petitioner, whole name was recommended alphabetically, not on merit, my lord. Kindly peruse that page 22, my lord, of the writ petition, my lord.
Here for the applicant.
Applicant, my lord. In the left side, left table, page 22, my lord.
Yes.
Here, the name of the present petitioner has appeared in serial number 1. Abdul Rahim. Here, AB, second letter is B. And secondly, Aminul Haq, the applicant. Here, A, thereafter M. Thereafter, Arif, A, thereafter R. So, alphabetically, name was prepared, not on merit, my lord. And
How do you say that? How do you say that?
My lord, the principal of the concerned school prepared this list and recommend and sent to the.
Who are you? Who are you?
Applicant, my lord.
No, applicant is who?
Stay vacating.
Applicant is the respondent. In the writ petition, respondent number.
Respondent number 6, my lord.
Yes.
And my last point, my lord. Kindly may peruse that page 7 of the writ petition, my lord. In entire petition, the petitioner has not mentioned the rule, any violation regarding the rule or notification. And page 7, paragraph 6, my lord. Paragraph 6. May I read, please, the lord? That the petitioner begs to state after preparation of the panel list, it was forwarded to the Deputy Commissioner Borpeta, that is the respondent number 3. It will be 3, my lord, for onward consideration, and accordingly, having found qualified and eligible, selected with due approval of the guardian minister concerned. So they have admitted, my lord. The applicant has selected with fulfilling the due process of the notifications.
May I submit your lordship? Lordship, may I submit your lordship?
You're the petitioner.
I am for the petitioner, Your Lordship. Here, what happens is that, Your Lordship, 4 names are sought, Your Lordship. Accordingly, the principal of the institution, Your Lordship, forwarded 4 names to the inspector of schools, Your Lordship. So inspector of school, Your Lordship, these 4 names are again forwarded to the, Your Lordship, to the deputy commissioner, Your Lordship. So my name is placed at serial number 1, Your Lordship. And so far, my adverse, this other side is concerned, he is taking the plea that, Your Lordship, that it is on alphabetically, but if it is alphabetically, but rest of the petitioner must have been also alphabetically made, Your Lordship. It is not that, Your Lordship. So what happens is that, Your Lordship, that we have challenged the impugn order dated, Lordship, page 24, Your Lordship. So that has been after perusal of, after hearing about the parties, Your Lordship, this impugn order has been suspended, Your Lordship, fight order dated 27.
I wish your order was seconded.
Lordship. Fight order date 27. Order to suspend police. 10 of the suspend.
Yes, 40.
Lordship, on 23/11/2022, Lordship. See, this impugn order has been, Your Lordship, suspended, Your Lordship. So thereafter, Your Lordship, so in this regard, Your Lordship, 2 notifications were followed, Your Lordship. That is, the first notification is at page, Lordship, it has page 17, annex 2, Your Lordship. And after modification, if some modifications were made, so thereafter second notification was done was
See, this is a stay vacating application.
stay vacating.
We are on the IA.
Yeah,
Let
it's
him,
for IA, Your
let
Lordship.
him submit. After that, you reply.
Mild. So, your lordship, on that.
What is your ground? What is your ground in the IA? For vacation
My
of
lord,
interim order?
the petitioner was selected in due process and conducting meeting was held, and that guardian meeting, the guardians, local representative and senior citizens who were present, and his name was recommended, and rightly wrongly 4 name was selected, my lord. For that, my name is appeared in serial number 2, my lord. So if it would be 3, 4, I would not have the issue, my lord. But my name recommended in serial number 2, and the principal of the concerned school referred to the IS, and IS was prepared the list, and thereafter it was selected by the DC, and DC referred, and it was approved by the guardian ministers, my lord. So whole process was followed, and last 21 notification, the recent notification, which was also followed, my lord. So there is no any lacunas.
State. Kaushik, you have a copy of the IA?
But yes. But our law is very limited.
No, your role is very limited here. Only the issue is that if I consider this IA, I'll be touching on the merits.
That is
That is the whole problem. Instead of this, why not we go for
better to
disposal
go
of
for a
the
final disposal.
final disposal? Have you filed your affidavit in the writ petition?
My lord.
Have you filed? You file your counter
Counter, my.
in the writ petition?
Yes, my. I have filed counter application with interlocutory application.
Huh?
For vacating petition.
No. Have you filed your counter affidavit in the writ- in the main? Can your IA be considered as a counter? Or you want to file a separate counter affidavit?
It may consider the IA as a counter application.
Okay.
Yes,
First, Mr.
MU.
M.U. Ahmed, learning counsel for the applicant in the IA. Also heard Mr. A. Diwan, learning counsel for the opposite party number. One. Public writ petitioner. As well as Mr. B. Kaushik, learned standing counsel Secondary education,
1, 2, and 4.
for respondents, 2, 3, and
1, 2, and 4.
2, 3, and 5. In the IA,
Oh, in the I.
and Mr. P. Cycle, the government advocate for the response number 4. Stop. After hearing the parties at length, comma, this court is of the consider opinion that if any order is passed in the present IA, it would have an effect on the merits of the main petition. In that view of the matter, comma, it would be in the interest of justice to dispose of the main petition at the earliest. Stop. Mr. M.U. Ahmed, learned counsel for the applicant submits that the present IA may be treated as a counter affidavit in the main petition number 6818 of 2022. Accordingly, comma, it is directed that the present IA will be treated as a counter affidavit. List the matter for final disposal. When do you want?
After 2 weeks, my lord. Time.
After 2 weeks.
That's
22.
all.
Wait, Lordship, this is also an application file for vacating the interim order dated.
Have you received a copy?
Yes, ma'am.
You are the
Okay,
you are
yes.
the writ petitioner.
I'm the repeat. But my
You want
humble
to file your objection?
no, my humble submission, my lord, let the matter be taken up for final disposal. In the meantime, you will file the affidavit in opposition. And otherwise, I will file objection. If he prays for the
Up
IA,
to you, Mr. Sharma.
My lord, the petitioner has no locus standi, my lord. Out of 1,000 of guardian, only 3 guardian has come before this honorable court.
So shall we go for early disposal of the writ petition?
Yes. That may be.
In the main petition, you say. It is the consensus of the legal counsel for the parties that this matter may be disposed of at an early date.
Yes.
Now, Mr. R. Islam, legal counsel.
for the
No. You want to file your counter affidavit,
My lord, my IA may be treated as an affidavit.
is it? Then cancel it.
My lord,
The
I have
IA
filed an
In the
IA.
IA you read. Heard Mr. N. Sharma.
Yes.
Learned counsel for the applicant. Also heard Mr. R. Islam, learned counsel for the opposite party number 1.
Yeah.
Oblique with petition. As well as who appears
1 to 3, my lord.
for the opposite party 1 to 3. Oblique with petitioners.
And they have paid for filing objection, my lord, against my IA
No, I'm treating your IA as a counter affidavit.
in the amended petition.
Do you want to file a separate counter affidavit?
My lord, if my IA is deferred, my lord, then along with the IA, the repetition may be taken. First, otherwise, that will be problem. I have filed the IA for stay vacation. There is no ground.
If he prays for the interlocutory application, then I may be allowed for 2 weeks to
Yes,
file the counter.
I'll press.
Okay.
Okay.
Then
That can-
cancel it again. Third, and Jamal and the counsel for the applicant. Mr. R. Islam. Then the counsel for the opposite party 1 to 3. Public petitions.
Yes, 2 weeks time.
2 weeks time to file objection. Praise the Lord.
Much.
That may be fixed, my lord.
It will come after 2 weeks.
23. Completement of party.
May it please your lordship.
What is this?
Your lordship, this underlying writ petition, your lordship, was filed by the opposite party number 1 for provincialization of his services as an assistant teacher language in Halbari ME Madrasa, Halbari Gwalpara. If your lordship can kindly come to page 15 of the IA for a moment, your lordship. Page 15. Paragraph number 12, your lordship.
Yes.
Yes, that the applicant begs to state that while the proposal for provincialization of services of the applicant as a language tutor in Halbari ME Madrasa, Halbari Gwalpara was under process in the office of the opposite party number 3,
The opposite party number 1 preferred WPC 5398 of 2022, which is the underlying writ petition, Your Lordship, challenging the order dated 19/2/2022 passed by the opposite party number 3, whereby the claim for provincialization of his services as a language teacher in Halbari ME Madrasa, Halbari, was rejected on the ground that relevant records pertaining to the services of the opposite party number 1 were not available with the authorities during the exercise of provincialization. Thereafter, Your Lordship will kindly come to for a moment, Your Lordship, page 66. Page 66, Your Lordship.
Yes.
Yes. This is an order dated 38/2022. With reference to the subject cited above, I have the honor to submit herewith the proposal for provincialization of service in respect of Jalaluddin, Your Lordship, who is the applicant here, assistant teacher, Halbari ME Madrasa, after recommendation of the DSC Gwalpara in compliance of the Honorable High Court order dated 7/12/2021, passed in so and so. And Your Lordship will come to the subsequent annexure, which is at the next page, Your Lordship. Respondent, page 67. This is the order, Your Lordship, which my learned friend for the opposite party number 1, Your Lordship, had assailed in the underlying writ petition. I am the necessary party, Your Lordship, and I need to be implemented, Your Lordship, because the post in question is the same post, and both of us will be aggrieved either way, one way or the other, depending on how the writ petition is disposed of.
Yes.
That is my only submission, Your Lordship.
My lord, in this case, my lord, the applicant here in my lord, he earlier approached the Honorable Court, my lord, claiming himself to be the teacher against the social science subject. The writ petitioner is claiming the post of language. Earlier, he approached this Honorable Court, claiming himself to be the social science teacher. Now he, my lord, claims that he is the language teacher.
So is he a necessary party?
But now he cannot claim the post of language teacher, my lord. It is his case, my lord, that he is a social science teacher, my lord. He's not a teacher
So he
against
wants to
language.
be implemented
Yes,
as
he
a
can
party.
very well
You have
respond.
any objections?
I have filed the objection. my
A
lord.
detailed objection is filed, Your Lordship. But the matter of the fact remains, Your Lordship, that the order at page 66 confers upon me that post, right or wrong. In fact, my learned senior friend should be able to provide all the reverments, Your Lordship, if I made a party. Because then I'm the affected party here, Your Lordship. I'm the necessary party who needs to be implemented.
Because I
If
have
this writ
claimed
petition
the
is
post-
allowed, then the order dated 38/2022 goes. Then I'll have to approach this Honorable Court again. So this is my humble submission, Your Lordship. Your Lordship, looking the merits as and when I'm implemented, Your Lordship. Thereafter, we can have a extensive argument and Lordship can close the matter.
How he can say, take a U-turn now. my lord. Earlier, before this Honorable Court, my lord, he filed a petition. I have also annexed the petition also. But will file, my objection, my lord, page 134.
Then all the more reason for me to be implemented and put these amendments on record, Your Lordship, in the writ petition.
Page,
Page 134, my lord. My objection, my lord. Relevant paragraph, my lord, page 134. Petition starts from, my lord, page 128.
Huh?
134, paragraph 8. It itself says that he is the teacher against the content subject. Now, Lakshmi, can you come to page 136? What was the prayer in that petition? One 136. Direct third prayer, my lord. By directing the respondent 2, 3, and 4 to incorporate the name of the petitioner for provincialization of his service as first assistant teacher against the subject to child sex. It's his prayer, my lord. His repetition.
so in that writ petition, you prayed for this thing.
In fact, that has not been cited in our IA, Your Lordship. In fact, my sole contention in this matter, Your Lordship, is that if the writ petition is allowed, whichever way Your Lordship determines, the order dated 38 goes. In fact, it is our pertinent submission before this court, Your Lordship, that we need to bring on subsequent development in the matter. If your lordship finds no substance in our arguments, your lordship will dismiss or allow my learned friend's petition. I'm the necessary party here. He's aggrieved by the order which has given me the right of provincialization against the language teacher of assistant teacher. And ideally, he should be challenging that order, your lordship. In fact, that order has also not been challenged. Whereas order dated 1912 has been challenged, your lordship. So if his case is allowed, I go.
Where was that? Page 66.
Page 66, your lordship. It's for recommendation. And he has challenged.
Are you challenging this order in the writ petition?
This order, my lord,
Page 66.
of the IA.
No, not of, yes, of the
This communication, not order.
19 February 2022. अपना edit petition अपनी challenge कोई सकता है तो हमारी recommendation.
That is, my lord, against that I have filed before an appeal, which is pending before the authority, ma'am, under section 14 of the Provincialization Act, my lord. An appeal is pending against that order, ma'am.
Then I think he's a party, referred as a party.
Yes.
Let him be implemented as a party. What is the difficulty?
My contention is that, my lord, I am claiming the post of language teacher. He was claiming the post of social science teacher. Against social science, my lord, I have no grievance. Let him be provincialized as social science teacher. Now, my lord, it is his admitted case that he is the social science teacher. Now, how can he, my lord, raise an
Is
objection?
social science or social studies?
Social science, social studies. Social studies.
227 अपनी ऐसे लिखी. Yes, this is one pertinent fact. My learned friend appeared for that writ petition, your lordship. The submissions.
This
were made.
I am aware of the facts of the
Yes.
case, my lord.
So that is
What is it?
My lord, in that case, my lord, I appear for the, my lord, applicant.
so that again puts a little turn on the events, your lordship.
Oh. You applied for the applicant.
Yes.
In that writ petition.
In that, while he claimed for the post of social science. He is not claiming the language post. That is why, my lord, I have no impediment in my lord, appearing for the other person against the language teacher.
And you are the petitioner in this writ
Yeah.
petition.
Yes, ma'am.
With
Who
utmost
is claiming the
sincerity,
post of
with
language
utmost sincerity, I submit your lordship. My learned friend had the power to appear for the writ petition in that writ petition. If he wishes to bring all of that and record in this writ petition where I am authorized to represent him, let him file an affidavit. Let me be included. There's a necessary party. Why should he be so worried, your lordship? It at least gives rise to
Now the problem is whether you can appear against him.
That is the only.
Yes,
question
your
that
lordship will
I
look
have
into
raised
that
the
also.
objection.
Your lordship will look into that also.
That is why, my lord, I am raising the objection because, my lord,
I raised the objection, not him, your lordship.
No, you are
The
raising no, whether you
propriety
can,
matter
you
has
can,
not been resolved.
you can appear against the applicant now.
what I'm saying, as his claim was for the post of social science.
No, that's fine. But then you were the writ petitioner there,
Yes,
correct? Now the applicant is coming for impeachment
now he is claiming the post of my lord,
language. The only issue is since you appeared in favor of the applicant in that writ
My
petition,
lord, that was a different prayer.
different prayer maybe.
Yes.
Can you appear against him now?
Some problem.
Some problem is
Not
there.
me, my lord. Well, I'll take instruction from my client, my lord, whether
You take instructions and come back.
But your lordship will at least implead my party here, your lordship.
No, let him take in there. How can he appear against you now?
That will jeopardize his case, your lordship, not my case. I would utmost.
Maybe, but
Yes.
there's a something else.
Yes. I'll leave it to your lordship. I'll leave it
He
to your
was
lordship.
appealing for you in that writ petition.
That is
Now,
how he's so aware of the facts.
Can he appear against you now?
He's appearing for me. I'll not mind if he comes across this side, but again, is
That's the problem.
that is the problem, my lord. I'm
Lord
finding
M.
it
Sharma,
difficult
learned
raising
counsel
of
to the
this
petitioner on request made by IS Cycle, learned counsel for the opposite party number one.
litigation.
Opposite petitioner. This the matter, 1 week will do.
One minute.
1 week.
After 24th, my lord.
1 week will come up.
24 admission.
My lord,
The board has verified a duplicate certificate of the petitioner, my lord, annexed in the additional affidavit, my lord. That has been verified, my lord, and found tally with the records of the board.
Lordship may record my submission of my learned friend. It was
Where's the instruction?
Instruction, my lord, provided through WhatsApp, my lord. I think so.
Can I record that?
Yes, ma'am.
Yes, what is, place your case?
Lordship, in this case, Lordship, petitioner applied for the post of assistant teacher, Lordship, under SSL, Lordship.
Page?
Lordship, that is, Lordship, kindly have a look at page 18, Lordship, is her application form.
Yes, then.
Lordship, thereafter, Lordship, document was verified. And when the select list was published, her name was not reflected in the select list.
Where's the list?
That is at Lordship, started from page 19 onward.
Yes.
On the ground that her date of birth was tampered. Then she filed a representation to the authority. Authority did not consider the representation. She preferred a
Where's your representation?
Lordship, that representation already disposed of. Then she preferred a writ petition before this honorable court. Honorable court directed to dispose of the writ petition, and that was
Where's that order?
Lordship, earlier order, Lordship. That is at page 27. Para 4, Lordship.
Yes, then.
That representation on the petitioner thereafter communicate the order, but Lordship, page 29, annexure 10, with a new ground that she failed to submit her document while the document on the day of scheduled date when the document was verified before the district scrutiny committee. New plea raised that it was on that occasion she failed, and there is also false, Lordship.
Yes, then proceed.
Lordship, operative portion may read. Moreover, from the perusal of the document annexed to the writ petition, that is WPC number such as such, it can be seen that duplicate HSLC certificates annexure 2 has been issued on 11/9/2017 by the concerned authority, meaning thereby Srimati such and such did not had proffered document as on 31/7/2017, and as such her candidature was rightly rejected in terms of the advertisement. It is a new plea taken, Lordship. Earlier their plea was that her date of birth was tampered. She lost her Lordship certificate and admit card. Immediately thereafter, she informed the police.
And on the receiving the police report, she applied for the lordship duplicate copy, and the authority Sheba issued a duplicate copy. That is lordship annexed to duplicate copy of this certificate. And inquiry report lordship annexure 5 page 23. Police inquiry report annexure 5 page 23. It was lost on 8/9/2017, and document was verified on 31st of July 2017. Lordship got it, page 23 of my writ petition, annexure 5.
Yes. Yes.
Lordship Mary. District Achar Assam lost a written information at Silchar police station to the effect that on 8/9/2017 at about 12 noon that below noted documents somewhere at in between such and such area from her custody. Inquiry has been made, but no trace till date. So it is the missing report was missing lordship report was lost on 8/9/17, and on that day report was given by the police, and thereafter she applied for the duplicate copy. Next page lordship, page 24.
Yes.
This is the duplicate copy, and now they have lordship taken a plea that while the document was verified, petitioner failed to submit any document before the authority. That's why her candidature was rightly rejected. That is a totally new plea taken by them. Earlier, their case was that the rejection was on the ground that her date of birth was tampered. That they failed to prove that. Duplicate copy also reflected her date of birth 27/12/75. So there is a no question of temperament lordship.
No, tampering issue is over.
Over. Now whether it is
Now
what
the question now is that whether you submitted all your documents.
document now, my learned friend already stated that it is tell you their record lordship. It is
No, he's for the SEBA, isn't it? You asked to verify the,
lordship document.
not the document, the admit card.
Certificate.
Come to the mic.
Hello, the Honorable Court has directed us to verify the duplicate caste certificate.
That's why.
Yes, ma'am. We have
So on
verified.
verification, you found that it is
It
correct.
tally with the record of
It
the-
tally with the records.
Yes, ma'am.
So there's no tampering.
Not
No.
tempered.
So the tampering part is over. Now whether you submitted the documents when you met your application.
Lordship, I'm getting confused.
Yes,
Lordship, I'm
come to the director's
Order, Lordship.
mission director's order,
Lord.
last para. The last para of page 29.
Yes, there is no challenge to the advertisement.
No.
Further, no reason.
No, moreover, from
Lordship.
page 29.
Moreover, from the perusal of document annexed to her writ petition, that is number such, it can be seen that duplicate HSLC certificate annexed to has been issued on 11/9/17. So lordship, it was lost on
No, that's fine. Continue.
by the concerned authority, meaning thereby Srimati Shomana Das did not had a proffered document as on 31/7/2017. That is how it is correct, lordship. It was lost on 8/9. That time my document was there, and it was submitted to the authority. It was a totally new plea they have taken, lordship. Document was verified, and it was lost after 2 months of the verification.
Where's your advertisement? Let us.
Advertisement, lordship, I have not annexed to the petition.
Where's your application?
Lord.
Application was page
Lordship,
Annexure 3, isn't it?
Lordship, it is annexure 3, page 18.
This is dated. On which date you applied?
Lordship, it is 1/7/2017. IPO
1/7.
2017.
When did you lose your certificate?
It was lost Lordship. It is on 8/9/2017. 8/9/2017.
So when you met your application, you had the original.
Lordship. And it was verified on 31/7/2017.
Yes.
So, my lord, their new plea is also not tenable, Lordship. It is afterthought and it is a false plea.
Yes. Who applied for
Police report
SSC?
also suggests that it was lost on 8/9.
Anybody for SSC? You're not appearing, Chicken? Let me check. Where's the SSA council?
Nobody is there.
No, SSC will have to answer this.
No.
Seba is clear about it.
Left.
24.
You call the SSA council. We'll take up after some time. After some time. Or we can fix a different date.
Any other date, Lordship?
Heard 11.
Short date, Lordship, after it.
Also heard Mr. DK Roy, Learned Standing Council Seba and MSS Chutia, Learned Standing Council, Elementary Education. None appears for the SSC. This is the matter again after 1 week.
Lordship, my friend submission may be recorded.
I have provided the instruction.
That will record later on. You keep the instructions with you.
Like
25.
Lordship, this matter will be taken up next week. Today, I'm typically on the part of my senior lordship.
Who's your senior?
RP Kakoti lordship.
Okay, heard Mr. R. Dubey. Learned Council. On request made on behalf of RP Kakuti, Learned Senior Council. For the IIT.
For IIT, all the respondents.
They're paying on behalf of all the respondents. This after 1 week,
1 week. Can a fixed date be given, madam?
it will come out.
Madam, date.
26 and 27.
May I please your lordship? Lordship, the petitioner is for your lordship been aggrieved by an order passed by the Director of Secondary Education. Lordship, here mainly there is a seniority dispute between the petitioner and the private respondent, and the
Private respondent number,
4 lordship.
today 4 is apparent. Yes. You are ready?
Lordship, I have not received the affidavit in opposition filed by the respondent number 8.
NCT. Have you furnished a copy? But MS.
Okay, Talukdar, Lordship, a short date may be given. Lordship.
Council for the petition. Mr.
Yes, Burman.
S.
Burman.
Barman.
Yes.
Learned counsel for respond number 4 submits that he has not received a copy of the affidavit filed by the respond number 8 oblique NCT. So, Mr. I Alam, learned studying counsel NCT shall furnish a copy of the affidavit in opposition to the learned counsel applying for respond number 4 within the course of the day. Within the course. of the day. Please submit after 1 week.
Lordship, next week, Lordship, on Thursday.
1 week.
Lordship.
Let him also.
Lordship, I pray for a date, Lordship, for a
It will
fixed date.
come up.
Lordship. Much obliged.
29.
Made please, your lordship. This is basically the third round of litigation by the petitioner seeking. Just a second.
is supposed to file a affidavit and we want also some time to file a affidavit. Because I'm looking for response number.
Separate locations here, lordship.
Where is J. Bigu? Secondary, who appears? Kishti,
Elementary.
elementary or secondary?
Elementary. There is an earlier order of this honorable. court, your lordship.
Furkan, are you appearing for elementary?
Yes, sir.
You're supposed to file your affidavit.
Lordship, we file. Lordship. By instruction, I will file it.
When?
After 2 weeks.
Third MS Laskar Learned Council for the petition. Mr. Furkan, the Standing Council Elementary Education is allowed. 2 weeks.
They also want to file your lordship. It may be recorded.
Who?
For respondent number, private respondent number 6.
Mr. Furkan, the Standing Council Elementary Education and Mr.
And Ahmed on behalf of Anbor.
and Ahmad Learned Council appearing
No, respondent number.
for the response number 6.
I have heard response number 7.
You also want to file?
Yes.
And Mr. H. Chetri, Learned Council appearing for response number 6. 7 jointly prays for 2 weeks time to file your respective counter affidavits. Praise a lot. Please, after 2 weeks.
Obliged.
30.
Lordship, in this case, your lordship, I have placed an instruction in lordship. Would like your lordship to have it.
Here too. ये दिया क्या?
He's taken.
Take charge. Contact them.
This first page.
Yes, sir. First page and second page.
What is?
With reference to subject cited above, I would like to inform you that in compliance with the Honorable High Court order dated 22/9/22, Fast and so-and-so, Preeti so-and-so is hereby directed to take the charge of the post of headmistress of the Assam Railway Hindi ME School till such time that the post of headmistress filled up on regular basis. So it has been done as per the order. Lordship. The order is at the next page. Lordship. Order dated 8/6/23. As per order dated 8/6/23, we have complied. Lordship.
But very surprising, my friend doesn't give me order then which is passed against me. And I'll point out to your lordships where when the stay was vacated in lord, it was directed a neutral person should be given till the issues are decided or final. But it's a virtually contempt of this honorable court, my lord.
I will give him a copy, but the fact of the matter is I have to first suppress the court before giving him a copy. Because this is between these things, he should not make statements like this, Your Lordship. I have got this from the department. I have to show the court first. After that, maybe I will give it to him. Then he has the chance to reply, but he should not make these kind of irresponsible statements, Your Lordship, against me, man.
You furnish him a copy.
I'll furnish him, man. I'll furnish him.
Lord, after 20 years of practice, I have to learn, Lord, the kind of submission I need to.
Whatever it is,
My lord will see what, my lord,
you want some time to take instructions?
yes, my
Here it says, I'll read
My
it
lord.
out. Here it says that District Elementary Education Officer Kamrup is hereby directed to take the charge of the post of headmistress of Assam Railway Hindi ME School till such time post of headmistress is filled up on regular basis. This was passed by order dated 1/10/2022.
That's charge has been taken, my lord. On the last day, your lordship was pleased to seek a direction, seek an instruction as to when they are going to fill up the post. Because the matter when the interim order was vacated, my lord, 3 months period was given. That has expired long back, nothing has been done. And on last occasion, the specific query from your lordship is that when it's going to fill up, my lord. That was the issue. Now he is placing something else without giving me any copy of, and he says that in terms of High Court order itself, this has been done, my lord.
Yes.
It should be,
I'll serve him a copy. Lord.
Order dated 2/8/2023.
As on date, Lordship, this is the instruction which I received. Then I have to get more.
No, this court passed a separate order, 2/8/2023.
He was declaring last time.
Yes, Kaushik was there.
Kaushik was there.
every day there is change of counsel from the department, my lord. One day one appear and the other day.
Can't help it, my lord. We have a numbers of lawyers.
There's a
in the-
panel
Yes.
so that we can stop the.
No, blood, I'm not, blood, what your lordship has.
Anyway, my lord, I have talked to the DEO.
Here, Kaushik, what this court directed you
Yes, yes, my lord, I have talked to the
was
DEO
to receive instructions with regard to the status
status.
on the process of filling up the post.
DEO
of-
has already requested the director to initiate the process of appointment because DEO is not the appointing authority as it is an ME school. And perhaps, my lord, it will take some time because it will have to initiate the process.
So you get an instruction on that.
As on today, my lord, my instruction is that the DEO has written to the director to initiate the process for appointing the regular headmaster. Lordship will take up after 3 weeks, my lord, some development.
Mr. R. Ravi, learned counsel for petition. Mr. B. Kaushik, learned standing counsel, Elementary Education Department submits.
By the time appearing on.
1 minute, that the DEO, concerned DEO has written to the
Director Elementary
Director Elementary Education to
initiate the process of
initiate the process of
promotion for the regular headmaster.
for promotion to the post of for promotion of regular headmistress of the Assam Railway Hindi ME School.
Well.
Stop. He therefore prays for further time to enable him to receive instructions. Stop. Prayer is allowed. List the matter again after.
Let it be after 4 weeks.
My lord,
Why
is
4
all
weeks?
instructions, my
Or
lord.
just make
Because-
it 2 weeks. 2 weeks.
It will take time, my lord, the promotion to,
Get the instructions, what
I'll-
the director is doing after he got.
yes,
it.
I'll do that.
After 2 weeks. MSK David, Leonard Council, appears for response number 5.
31 and 32.
May I please, your lordships? In this case, lordship, Pandit Dindayal Upadhyay Adarsh Mahavidyalaya, the authority issued advertisement for filling up of some posts, including 2 posts of Chowkidar. One was reserved for OBC and other was unreserved. Petitioner being unreserved category applied for the same. Altogether 20 persons applied. Out of 20 lordships, 13 belongs to general and others, 13 belongs to OBC and others belongs to general category. As per merit list, name of the petitioner appeared as serial number 2. all the 20 candidates have been asked for appear in the interview, but appear 6, only appeared 9. In the general category lordships, candidate number 1,
I need some time to file affidavit.
affidavit is required. 2 cases earlier, I filed.
That has been taken
that-
along with.
Yes, that has been tagged. In present case is required to file an affidavit lordship. Clarification is required.
Heard a few bar we are the council. Mr. S. Das. Then it's standing council higher education. Yes, my lord. I'm paying. Place for. 3 weeks time. 3 weeks time. In both the writ petitions.
Yes. Higher education. I got to file policy already.
In earlier, my lord.
They filed affidavit that I have
Affidavit has
annexed in
filed
my
already.
present writ petitions. Matter
For 3 weeks time.
lordships
File affidavit in WBC number 59 of 20.
and matter relates to 2017
List
already
of
lordships. I am praying your lordship convenience date may be fixed lordships.
It will come up for where.
Lordships. Oblige.
I think in this case, I take some time to file my reply, Lordship.
Counter.
Counter opposition.
My lord, the government is also supposed to file their affidavit, my lord.
Third, he was assistant and the council to the petition. Mr.
As for
Yes.
CRT.
Moral and standing council, SCRT,
And M does for respondent
and M Das, then the council for the respond number 4. Or both allowed how much time?
4 weeks time.
4 weeks time.
A date may fix, my lord, and another similar cases that may tagged along with the 3718-2023.
It's this matter. Begin on 15th September 2023, along with WBC number
3718-2023. Oblige.
35 order. Thirty-five.
who appears elementary education. None appears for the petitioner. Oh, no, say like this. Oh, this appears.
Sorry, Malot. I am paying for the petitioner, Malot.
Yes. I was going to dismiss it.
Malot, they are working as a, Malot. The affidavit is yet to file by the SSA authority, Malot.
Notice has been served.
Malot.
Notice has been served on all the respondents.
SSA is there, Malot.
Respondents 6 and 7, have you? Notice are complete?
They are working as a, who can
I'm asking you
help
one
her?
question,
Malot.
whether the notice on respondents 6 and 7 are complete.
Malot, I am not verified the case record, that is why.
You've not taken dusty service
Malot.
and you filed an affidavit stating that the Binapani LP school has been merged
With another,
with another school.
Malot,
So you may have to change the course title.
Malot.
Yeah.
Or some time may be allowed for the time.
Make the answer, sir.
Mr.
UK Goswami.
On request made by Mr. UK Goswami, list the matter up to 2 weeks.
Hello.
36 and 37.
Lordship, in this case, I appear for the respondent number 3, 4, and 5. We have filed our affidavit yesterday. That is not.
3, 4, and 5.
5.
In which writ petition?
In both the writ petitions, Lordship.
Both are same number.
Same number.
Okay, I am for respondent number 8 in number 7, 37. 7. Respondent number 7 for item number 36. I also filed my affidavit application committee.
I have not received a copy from the private.
I have after copy with the senior counsel, his name is on the.
Okay.
But there is one document it has been lifted for order because respondent
Lordship,
number 6.
as per office note dated 17/6/2023, my lord. Service is complete, my lord. Because the respondent number 6 in the 2018 writ petition and the respondent number 6 in 2019 are the same, my lord. And as such, the service is complete, my lord. It reflects from the office note, my lord.
The respondent number 6 in WPC 9195 of 2019. In this case, I think the office note will show that he has not been served.
No.
Because he has been made party by name. That is the difficulty. Otherwise, I could have represented being the governing body. But he has been shown as shown by name. The selection committee's chairperson has been shown by name. So he has to take the necessary steps.
Lordship, there is no necessity for taking steps, my lord.
Someone.
No. One is by designation and one is by name.
Lordship,
Notice has to go.
my lord. Because, but they are the same person, my lord. The in the writ
It
petition
is the same person,
2018.
there's no doubt, but
My
then one is by name.
Both are in by
Both are
name.
by name,
Both are
Lordship.
name, my
And
lord.
that person
And
is no
in the
longer there.
2018, the person has been
Person is
duly
no longer-
represented, my lord.
No longer there.
No longer there as the chairperson. He is no longer as the president of the governing body.
Okay.
So Lordship, he has to take a necessary step.
Then who's holding the post of
Lordship,
president?
there is a new incumbent, Lordship. I'll get to the name, but he has to correct the cost title otherwise.
Yes.
My lord.
How much time you require?
In that case, my lord, after first, you have to first give me the name, my lord. Thereafter, I can
I'll
say.
provide him the name today, sir. It's not difficult. I will
I'll
provide
give
him
you 2
now.
weeks time.
Required.
1 week, my lord.
On request made by Mr.
As Chaudhary.
S. Chowdhury, let me counsel for the text.
38.
Public.
Violation of this honorable court's order dated 22/1/2019, my lord. My lord,
I'm appealing for the earlier commissioner.
they keep on changing. The incumbent, respondent.
What happened, Lordship, the entire
That
file-
we can't help it.
Yes,
My lord, still it's not implemented.
Lordship, I have given the instruction, Lordship, that entire file has been sent to the senior citizen for his legal review because there is another order passed by this honorable court.
You are appearing for who?
For the earlier commissioner secretary Pitam Sokia Lordship and the director Lordship. Pitam Sokia has already been retired. The present secretary is not a party. Anyway, Lordship, now the entire matter has been sent to the senior citizen for his legal review because one contradictory judgment has been come from this honorable court. So department has sought a legal view, Lordship. So 2 weeks time may kindly be given, Lordship. Otherwise, he is waiting, Lordship.
My lord, there is an urgency. My lord, there is admittedly, it's a violation of this honorable court order. It's up to your losses. Because I impeded the relevant parties at the relevant point of time. Subsequently, I re-implemented the new incumbent, my lord. Still violating, my lord. They keep on saying this, that their opinion. Well, their opinion is their internal matter. My lord, this honorable court's order is violated. So I'm up, it's up to your losses, my lord. Order of 2019, January 2019, we are in 2023, my lord.
Heard UK Kuswami, learning counsel for. Mr. Request made by Mr. S.M.P. Christie, learning counsel for respondent 1 and 2. Praise for 2 weeks time, to enable him to receive instructions. Stop, praise allowed, list the matter up to 2 weeks. On which date appropriate instructions shall be.
Yes,
published by the learned counsel.
I will respond. Yes. Obliged.
39.
May I please your lordship?
Yes.
The my lord, which matter is partially allowed. Already been, yeah, I'm getting salary, regular salary I'm getting, but area salary I'm not been receiving. Lordship, this judgment, my judgment was passed, that is WBC 7-47-2017. On
Page,
49-2000 in terms of the, or
Page.
judgment, or that is, my lord, your lordship will get it from, starting from annex of 40, relevant para, my lord, 42 page. Not para, page, my lord, sorry, page 42. Lordship, number 4, however, it has been stated that the bar appeal preferred against the decision. This the main. Number 2, number pertains to grant of regular time scale pay attached to the post of decision. So and so 7/6/2000, whereby court is directed to grant regular time scale as well as to the person decision. Accordingly, lastly, my lord, last page 43. Accordingly, this petition is disposed of with a direction to the respondent authorities to verify the said claim of the petition, and if it is found that they are similarly situated as the petition WBC number 7/6/2000, similar benefit of regular time scale pay may be granted to petition or exercise shall be undertaken with a period of counter decision. Now, my lord, that's, I'll take your lordship for troubling for time being. This is what judgment was passed in 7/6, my lord. That is lordship page 24. Lordship page 24. That was the my base case, that is murder case, 7/63/2013. Consequently, lordship got it. Para 8. Currently, both the questions time frame, this one, so and so order, so and so answered. Therefore, the respondents are directed to release the regular pay scale of the petitioners as gazetted and the date of their joining. And the same shall be done within a period of 4 months from the date of decision. So, if the failure of the pay scale, the petitioner directed to about decision, the area amount would be
So
carried.
are you receiving your pay scale?
Yes, I am getting pay scale regarding area. Now, yesterday I have confirmed from my clients that regarding this 7/63, this base case, this murder's case, that was the authorities trying to finalize the matter within 1 month or 2 months. That is why we have also to wait for that. That's why maybe listed after.
And moreover, lordship, all the respondents were already been retired, lordship, in this case,
Yes.
some cases.
Pitam Saikia, he is appearing.
No. No.
Huh?
Pitam Saikia retired long back, Jidung was transferred, and the inspector school also already been transferred long back.
If it is required, I'll complete. If
All the
he's
3
saying,
persons have to be present.
if my learned friend is intends to that I should file as his submission that Pitam Saikia, Mr. Pitam Saikia already retired.
Jidung is transferred.
And Jidumani also, whatever may be. Now, if it is required to implead, I'll implead. But the basic question is, my lord, here, if 7/63 petition is complied, then everything will be over. That is why let first decide on this one within 1 month.
Mr. C. Barwa, let it
First,
counsel.
and it will be that will be taken care of.
Okay, fine. I'll implead. Let him give me numbers.
Mr. C. Barwa, let it counsel. The petition is allowed. 2 weeks time, 3 weeks time.
2 weeks time, maybe given an indemnity, I'll implead. Is he'll furnish me.
Lot of 3 weeks time.
File an application.
3 weeks time?
Point
3 weeks time.
3 weeks time, okay, fine. 2 weeks time.
Weeks up to 3 weeks.
My lord.
Apply for this.
40 and 41.
May please your lordship. There was the official note dated 27/7/2023. My lordship, we have taken step upon the 27/7.
In this contempt case,
Yes, my lordship, we have filed an I application for implement of party. We have been allowed. We have taken step, but same has been returned back
1 minute.
by answer.
It has not come back. AD card not received, unserved notice not come back.
Yes, answer return, not return. So kindly allow the cost title is the correct address of the party respondent.
What is it?
Actually, we have Narayan Kaur IAS Secretary, Department of Elementary Education. It might be Secretary, Department of School Education, Govt of Assam.
That's what you put in there.
But in our IA application, we have written as elementary education.
Where?
Our IA application.
No, it has been implemented here in the post title as Secretary School Education.
Secretary.
Huh.
For,
You take first steps.
yes, my lord.
MS
R. Begum.
or become learned counsel for the petitioner. Is allowed to take first steps. Petitioner in the contempt case. Is allowed to take first steps for service of notice on the response number 2 by registered post AD within 1 week.
Yes, my lord.
Please the matter after 4 weeks.
Obliged, my lord.
42.
Lordship, in that case, I am appearing for the respondent number 4, Lordship. Already inquiry has already been conducted by the inspector of the schools. I have just received the soft copy, Lordship. So I will place it on the next week, Lordship.
Let an affidavit be filed, Lordship, in that regard.
Okay, MS, heard MS, A Taluk learned counsel for. Mr.
H. Bezura.
H. Basbora, learned counsel for the response number
Respondent
4.
4.
Is allowed, how much time? 1 week, 2
One
weeks?
is Lordship.
Is allowed a week's time to file after. This after 1 week.
Much obliged.
43 and 44.
Wait, please, Lordship. The Lordship, on the last occasion, on the 23/6/2023, your Lordship. The Lordship had directed us to file an affidavit on respondent, behalf of respondent 3, 4, and 5. It is my submission at the bar, your Lordship, that we have prepared the affidavit. There is one annexure which is yet to be provided to us by the client. The Lordship has granted us one last week. If within that week you do not file our affidavit, the Lordship will proceed in the base of the materials for the court. That is my submission.
Okay, I'll grant you 2 weeks as
Lordship.
last.
I'm grateful, I'm grateful.
But only my only prayer, Lordship, Lordship would kindly fix a date, your Lordship.
Heard Mr. RM Deka.
Lordship, and what?
Oh, I'm sorry, N Gautam, learned counsel for the. Mr.
M.
M.
Sharma.
Sharma, learned counsel for respondents
3,
3,
4,
4,
and
and 5 is allowed 2 weeks time as last chance.
Yes, yes.
To file counter. List the matter on 30.
Lordship.
I'm grateful, your Lordship.
45.
Lordship, compare with, we have passed being order, and the community of the petitioners also, Lord.
Yes,
We have got a copy, Lordship, from the petitioner, but this also exactly there is no mention, Lordship, that representation is complied with. Here it is mentioned about appointment of principal.
Madam, may kindly pay us last portion, honorable court, so that is complied with, Lordship.
which portion?
Last portion, Lordship. You want the phone? If he is still agree, he can file, Lordship, with another petition.
It should be at liberty to challenge disposal of liberty.
No liberty is required. This is a contempt petition. You are Mr.
NZ Chaudhary, on behalf of Mr. Priya
MZ.
Chaudhary.
Heard Mr. MZ Chowdhury, learned counsel appearing on behalf of learned counsel. Mr. K. Gogoi, learned counsel appearing for respond number.
So content.
For the sole respondent has produced an order dated 5/8/2023 issued by the Director of Higher Education, Assam. Stop. A perusal of the said order indicates that substantial compliance has been made to the directions passed by this court. Accordingly, this contempt petition is closed. The order dated 5/8/2023 is placed on the court.
Obliged.
47.
Lordship, step was already taken upon the sole respondent on 28/6/2023. But however, my lord, neither the AD card, as per office note dated 9/8/2023, neither the AD card nor answered notice has been received back in response to the notice issued. So, my lord, we may wait some more time.
Await service report on the respondent, on the sole respondent. And this is the matter after 2 weeks.
Obliged, fine.
48.
May I please, Your Lordship? Earlier occasion, they took time for file their affidavit in opposition.
But why is it coming for orders?
They are not filing their affidavit, that's why.
That will be for admission, Lordship.
Five and six.
If I am appearing for respondent number 6, if I pray for a further time of 3 weeks,
Oh, you are paying for respond number 6
I am appearing for respondent number 6.
and 5? Okay, then the notice is complete. Third MS,
A Begum.
A Begum, learned counsel for the petitioner. Mr.
A Chakraborty.
A Chakraborty, learned counsel, appearing for the respond number 6 and MS
J Tamuli.
J
Tamuli.
Kanguli, learned counsel, appearing for respond number 5. Praise for
3 weeks time.
Lordship,
Jen-
2
Jen-
weeks
Praise-
time. 4 weeks.
Then-
Doctor,
then the
23
rest
matter
3 weeks
does not-
time to file contract.
23 matter, earlier occasion you are
There is
took
an-
time for.
List the matter after 3 weeks in the admission column.
Obliged,
There's
sir.
an order, already an order for listing it in the admission column. They have listed in the orders.
Deeply opposite.
49.
My lord, take up the 49 and 50 together, my lord.
Yeah.
It's a
You-
contempt.
You contempt, no.
It's a contempt, my lord.
Notice
Notices,
has gone.
notices, we have taken steps, my lord.
What does it say?
Steps were taken on 26/3, my lord.
26/6.
Yeah, 26/6. 23/6, sorry.
You want to await service report or you want to take first steps?
We'll take a fresh step.
Mr. H. Amal and its counsel for the petitioner. Praise for taking first steps for service of notice. Sole respondent.
Yeah, I know. Yeah, here it is, my lord.
Oh.
Yeah, my lord, two respondents,
On the respondent.
two respondents.
I registered for on the respondents, praise Allah. Petition is allowed to take first steps for service of notice on the respondents by registered post within a period of 1 week.
My lord, one.
1 week. This the matter of the 4 weeks. Same order in the other case.
In the 50. Obliged.
51. Fifty-one.
None appears for this after 1.
52.
May I please, your lordship? The first time, lordship, is contempt has come up,
Who is
lordship.
the order?
The order is the 10th of March 2023. I have filed representation, that is annexed to page 12. On 16th of March, I have filed, but till date they have not passed any speaking order, lordship. Although mandamus is given,
Let
lordship.
me say they call then the council. Issue notice. Petitioner takes steps for service of notice on the sole respondent
Shoulder.
by registered post within 1 week.
Yes, Lord.
1 week. This the matter of the 6 weeks.
Obliged, lordship.
53.
Lordship, may kindly present the order dated 15/2/2023. Passed by your lordship.
15.
Instruction was sought for. 15/2/23.
Yes.
My lord, in this case,
Why is it coming for orders? But
that is the thing, it's wrongly listed in orders, lordship.
Are there any private respondents?
No private respondent, nothing, Lordship. Or everything done, no notices has to be served anymore. They only had, but
I don't know.
yes.
Instruction is awaited, my after 3 weeks.
No, sir, it's a long way. Lordship, what happened after this order rule was issued, Lordship?
Huh?
Yes, after this order rule was issued, it was not necessary for rule to be issued that time, Lordship. Without seeing this order, and another order is passed.
So rule has been issued, it should come up for hearing.
It is, Lordship, then it can, it's a very urgent matter. This man doesn't, he's under private loan, Lordship, due to their fault. So Lordship, Lordship fix it at hearing matter, let it come on Tuesday, and Lordship may dispose it in other stays, or there is no bar.
After 3 weeks, Lordship, in the meantime, we will file a
3 weeks. They are saying there's some urgency involved with the matter.
It is a very, very urgent matter, Lordship. Lordship, he's under debt, private debt. He was not paid salary for 2-3 years, Lordship, and he had to take private loans. Lordship may kindly fix the matter, just the fixed date may be given and the matter may be heard and disposed of. It's not a big matter,
And
Lordship.
after 2 weeks, my lord. After 2 weeks, my lord.
Third MS S. Parvin, the responsible for package. Standing council,
Elementary education.
elementary education. No, I'm looking at MS. Standing council is allowed 2 weeks time to receive it. 2 weeks.
My
2 weeks time to receive it.
Lordship, may I pray for fixed date, Lordship, on a hearing day?
The matter again on. Oh. 31st August. That's a hearing.
apply.
Let it be on 30th, Lordship, because it can come up in a hearing there, Lordship.
30 is a motion day. Miscellaneous day.
Wednesday, by the
Oh,
Thursday.
sorry, sir, I was, Lordship, I was obliged, your Lordship.
59 of supplementary list.
Well, in this case, our service is complete, otherwise it may come for admission hearing, and in the meantime, my UGC may file their affidavit, it's important there on.
Service is complete.
All are present, ma'am.
I'm putting. 1 minute, let me have a look.
Private respondent also there, college authority is also there.
We can't. College. Higher education.
Higher education, college.
Assam University.
I suppose they have the standing council.
Yeah, please. Then Guwahati. Yeah. UGC. Yeah. And Director General Council of Scientific and Industrial Research.
CGC, my lord, they're taking.
Then Kamrup College.
Yes, they had the council.
College
my
has
lord.
appeared.
Respondent number 7, I have.
Yeah, please. And 89. 89.
And looking for respondent number 10, newly implicated party. Lord. Yes, Lord. Newly implicated party, but
There's no implicit of parties. Did you implicate the new respondent?
No, respondent to naam ki.
implicated party.
Kritika Dehinga, who is it?
The newly implemented part, my lord.
Acha, okay, you have, they filed an IA for implementation which was allowed, I suppose. Yes. Purga is the. Purga.
Lordship, the respo-
You'll have to file an amended cost title.
But they have, my lord, filed the miscase, they have implemented.
Whatever it is, there's a notification that once an implementation is done, you'll have to file an amended cost title, only the amended cost title.
On the names.
Putting the name. No, amended cost title. With regard to the respondents. A2PS change code. এই পেজটো তাত amended বুলি আহিব, এই দুটা পেজ। এই দুটা পেজ। Mr. P. Purkayasta. Is allowed 1 week time will do, 1 week time. You file an amendment. Stop. So your name in the. This the letter after 1 week.
My lord, let it come after 2-3 weeks, 3 weeks, my lord. By this time
No,
they
you
will file.
file your amended.
I will, in the meantime, I will file, my
After
lord.
that will pass appropriate orders.
Or then a
After
date
that
may be
we'll
given, my
pass
lord.
appropriate orders.
Then a date may be given in the first week of September, my lord.
I'm giving you 1 week to file your amended application.
It will come automatically after 1 week.
Lordship, our name may be reflected in the qualification.
Who?
Respondent number 10, Lordship.
Registry is also directed to reflect the name of MS.
TP Das, Lordship.
BB Das, London Council for the respond number 10 in the post tag, in the post list.
Okay.